Justice Sengu Kuruma. We have arrived at the declaration sought by the seventh defendant, though for different reasons, which will appear in the respective judgments. My lords, my lady, this case deals with a matter of great public interest and importance. It deals with the question of who is citizen of Sierra Leone in terms of the Constitution of Sierra Leone 1991, Act number 12 of 1991, for the purposes of contesting presidential and/or parliamentary elections, and at what point in time that person loses his citizenship, and whether, having lost it, he could regain it at a later date. The question also involves the procedure to be followed for divesting oneself of one's citizenship. In other words, how does one renounce one's citizenship under Sierra Leone law? This question by itself does not raise any constitutional issue. It merely deals with the interpretation of a statute, the Sierra Leone Citizenship Act 1973, as amended in 1976, in 2006, and in 2017, respectively. This issue could have been dealt with in the High Court. Further, as far as issues of eligibility relating to parliamentary elections are concerned, these are issues which ought to be dealt with by and in the High Court, and in accordance with the Public Elections Act 2012. Further, Section 78, Subsection 1 of the Constitution of Sierra Leone 1991, Act number 6 of 1991, hereafter the 1991 Constitution, provides that the High Court shall have jurisdiction to hear and determine any question whether any person has been validly elected as a member of Parliament. In other words, issues dealing with nomination as a candidate and contesting parliamentary elections as a candidate are matters exclusively for the High Court. The Supreme Court has no jurisdiction to deal with such issues standing by themselves. Appeals relating to parliamentary elections, such as those concerning a candidate's eligibility to contest such elections and the manner in which they have been nominated for such elections, can only be made as far as the Court of Appeal. They can go no further. But where the issue is the citizenship of a candidate for a presidential election, that issue can only be brought before and dealt with by this court. The Supreme Court can only exercise its original jurisdiction to interpret a statute if it falls within the ambit of Section 127, Subsection 1 of the Constitution, which says, a person who alleges that an enactment or anything contained in or done under the authority of that or any other enactment is inconsistent with or is in contravention of a provision of this Constitution may at any time bring an action in the Supreme Court for a declaration to that effect. The plaintiff here has not directly invoked Section 127, Subsection 1 of the 1991 Constitution, but in challenging the correctness of the decision taken by the third and fourth defendants herein to accept the nomination of the first defendant as a candidate for both the presidential and parliamentary elections in 2018, he is impliedly invoking that constitutional provision. He is saying that both these respective defendants have done something under the authority of an enactment, the Public Elections Act 2012, which is inconsistent with and contravention of sections 41, 75, and 76, subsection 1, paragraph A of the 1991 Constitution, namely, that they accepted for nomination someone, that is the first defendant, who did not satisfy the eligibility criteria in sections 41, 75, and 76 respectively of the 1991 Constitution. The specific criterion he claims has not been and was not satisfied by first defendant was citizenship. That criterion being that the candidate for both elections must be a citizen of Sierra Leone, otherwise than by naturalization, and should not at the same time be a citizen of another country. He alleges that first defendant was a dual citizen of both the United States and of Sierra Leone at the time he was nominated as a candidate in both elections. If he is correct in this respect, this court, in my respectful view, could make some of the declarations he sought. Section 127, subsection 2 states as follows: the Supreme Court shall, for the purpose of a declaration under subsection 1, make such orders and give such directions as it may consider appropriate for giving effect to or enabling effect to be given to the declaration so made. Theoretically, it follows that in 2018, this court agreed that third and fourth defendants had acted wrongly or in contravention of the provisions of this constitution. We could have, in the exercise of our discretion, treated the plaintiff's originating notice of motion as the objection filed pursuant to the provisions of Section 47, Subsection 3 of the Public Elections Act 2012, which states, an objection against the nomination of a presidential candidate shall be heard by the Supreme Court, made up of 3 justices, whose decision shall be given within 30 days of the lodging of the objection. The business of this court in its original jurisdiction is to adjudicate on claims brought to it. But in order for this court, theoretically, I must again emphasize, to have entertained any such objection as provided for in Section 47, Subsection 3 of the Public Elections Act 2012, assuming that provision did not and does not contravene any constitutional provision, the person taking the objection should have first complied with the provisions of Section 47, Subsection 2 of the Public Elections Act 2012, which states inter alia that the government notice referred to in subsection 1 shall direct that any citizen of Sierra Leone may lodge an objection, if any, against the nomination of a presidential candidate, but that the objection shall be lodged with the Supreme Court within 7 days of the publication of the government notice. That government notice is exhibited as DF1 to the plaintiff's affidavit of 5th February 2018. That is, the affidavit was filed within the 7-day period stipulated in Section 47, Subsection 3. The originating notice of motion was filed on the same day. This court has decided in Supreme Court cases numbers 6 and 7 of 2018, Dr. Sylvia Blyden, Dr. Samuel Kamara, and others, the Honorable Chief Justice, Justice Edwards, myself, Justice Roberts, Justice Alusain Sise, Justice of the Supreme Court, and Justice Ivan Sise, Justice of Appeal, the Honorable Chief Justice, Justice Edwards, delivering the unanimous decision of the court that when statute, in particular the Public Elections Act 2012, provides that any action should be brought to this court in its original jurisdiction, it has to be brought by way of originating notice of motion. In dealing with the challenge to the election of a president, the learned Chief Justice said at page 93 of the judgment, the originating process mentioned there as the way of invoking the original jurisdiction of the Supreme Court thus becomes the only way and law applicable to challenging the validity of presidential election results pursuant to Section 45, Subsection 2 of the Constitution. The mention of by petition in the Supreme Court becomes destitute of any legal effect to the level of its inconsistency with the 1991 Constitution, in the sense that there cannot be another process of invoking the original jurisdiction of the Supreme Court by petition when the said Constitution already recognizes and applies originating notice of motion process through the Supreme Court rules or existing law. End of quotation. There, this court was dealing with a challenge to the election of our current president. But as I shall show hereafter, that conclusion applies equally to a challenge to the eligibility of a candidate to contest a presidential election. Section 122, subsection 2 of the Constitution states, the Supreme Court may, while treating its own previous decisions as normally binding, depart from a previous decision when it appears, should be IT, when it appears so to do, right so to do. I concord in and with that decision, that is the Dr. Sylvia Blyden and others' decision, and I see no reason to depart from it. There are several important implications flowing from this decision. Any such action that is an original action in this court should be dealt with in accordance with Supreme Court Rules 1982, Statutory Instrument number 1 of 1982, made pursuant to powers conferred on the Rules of Court Committee by the 1991 Constitution and its predecessor, the 1978 Constitution. This means that the originating notice of motion could only have been heard at the earliest 21 days after 5th February 2018, that is on 26th February 2018. The plaintiff filed the statement of case on 15th February 2018. Each defendant had another 10 days within which to file his or its statement of case. That would have taken things up to 25th February. Both presidential and parliamentary elections were already fixed for 7th March 2018, 10 days away from 25th February 2018. But other events intervened. On 27th February 2018, the 5th, 6th, and 7th defendants filed a motion in this court asking to be joined as parties. That motion was heard on 1st March 2018 by 3-judge panel fixed by Mr. Justice Cham, then Chief Justice, that is, myself, Justice Roberts and Justice Thompson, Justices of the Supreme Court, as stipulated in Section 47, Subsection 3 of the Public Elections Act 2012. Mr. Justice Cham, then Chief Justice, was right in this respect. He was also acting in accordance with the provisions of Section 126 of the 1991 Constitution. The Court first had to consider the application for joinder, which was interlocutory in nature, because it did not finally determine the cause or matter, before hearing the plaintiff's substantive originating motion. The constitutional provision dealing with the quorum for a Supreme Court hearing in Section 126 of the 1991 Constitution, referred to above in paragraph 9, which states as follows: a single justice of the Supreme Court acting in its criminal jurisdiction and 3 justices of the Supreme Court acting in its civil jurisdiction may exercise any power vested in the Supreme Court not involving the decision of a cause or matter before the Supreme Court, save that a. in criminal matters, if any such justice refuses or grants an application in the exercise of any such power, any person affected thereby shall be entitled to have the application determined by the Supreme Court constituted by 3 justices thereof. And in civil matters, any order, direction, or decision made or given by the 3 justices in pursuance of the powers conferred by this section may be varied, discharged, or reversed by the Supreme Court constituted by 5 justices thereof. It follows that whatever decision the 3-man panel gave would have been subject to reversal or variation by the full panel of 5 justices. Also, it was clear that in order not to contravene Section 126 of the 1991 Constitution, it was mandatory that a full panel of 5 justices should preside over the plaintiff's originating motion. Thus, Section 47, Subsection 3 of the Public Elections Act 2012 is in this respect clearly inconsistent with the provisions in Section 126 of the 1991 Constitution. A 3-member panel of this court cannot finally decide an original action. Section 126 requires no interpretation. Its wording is clear and unambiguous. The application made by the 5th, 6th, and 7th defendants was one which the court could not refuse. First defendant was the presidential candidate for the 7th defendant, the National Grand Coalition. If the plaintiff succeeded in his action, the party would have to find another candidate. The 5th was and is the chairman of the party. The 6th defendant was at the time Secretary General of the 7th dependent party. The application was granted. Consequential orders were also made, including fixing the date of hearing of plaintiff's substantive originating motion on 2nd March 2018 at 2:30 p.m. Time for filing respective statements of case by the additional defendants was abridged to 24 hours because of the exigencies of the situation. The 6th order I made, and in which Mr. Justice Roberts and Mr. Justice Thompson concurred, was as follows. 6. In view of the questions raised for determination in the substantive originating notice of motion, the full court of 5 justices will be sitting tomorrow. In paragraph 11 above, I have already explained the necessity for such an order. Indeed, at that next hearing on Friday, 2nd March 2018, the full bench of 5 justices did it. Objection was taken to the presence of 2 of the justices on the full panel. Those justices recused themselves, and 2 other justices of the Supreme Court replaced them at the hearing the following Tuesday, 6th March 2018, after Mr. Justice Cham, then Chief Justice, had reconstituted the panel the previous Monday, 5th March 2018. That being the case, it was quite obvious that a decision could not be given by the court within 30 days of 5th February 2018 as stipulated in Section 47, Subsection 3 of the Public Elections Act 2012. And again, Mr. Justice Edwards, Chief Justice, has, with the unanimous concurrence of the other justices in the case cited above, Dr. Sylvia Blyden and others against His Excellency President Julius Maada Bio and others, ruled that the Constitution takes precedence as it should over any other enactment. In this respect also, Section 47, Subsection 3 of the Public Elections Act 2012 is clearly inconsistent with the provisions of Section 126 of the Constitution. Having dealt in some measure with the provisions in the Public Elections Act 2012, which deal with the manner in which the challenge to the nomination of a candidate for a presidential election ought to be carried out, and consequently pointing out where those provisions are inconsistent with those in the 1991 Constitution, I shall go on to deal with the corollary and perhaps the principal issue brought up by the plaintiff, which is whether being a citizen of another country while maintaining one's citizenship of Sierra Leone deprives one of the rights to contest election in Sierra Leone for the presidency. This issue calls for the interpretation of Section 76, Subsection 1, Subsection A of the 1991 Constitution. During the course of the hearing, the plaintiff discontinued their entire action against all defendants. This was done after all parties had filed or had been given leave to file out of time their respective statements of case. In these circumstances, counsel for the seventh defendant requested that this court make a pronouncement on one of the reliefs it had sought so that there might be clarity on the issue as to when a citizen of Sierra Leone loses his citizenship and consequently his eligibility to contest presidential and parliamentary elections. The court agreed that it would do so, and I shall do so in the course of this judgment. But first, it is necessary to set out the origins of the action and the course it took in this court, as this procedure would have some bearings on the issue of costs at the end of the day. The plaintiff, David FORNA, as stated above, on 5th February 2018, filed in this court's registry an originating notice of motion posing certain questions which, according to his solicitors and counsel, needed to be answered by the court. And if they were answered in a certain manner, several declarations were sought. The action was initially brought against ALHAJI Dr. KANDEH YUMKELLA, the Attorney General and Minister of Justice, the Chief Electoral Commissioner Mohamed Infa Ali Conte, and the National Electoral Commission. Later in the proceedings, as indicated above, on the application of counsel for the first defendant, Dr. Yumkella, and by order of this court, the other three defendants were added on, namely Dr. Dennis Bright, Chairman, National Gun Coalition, Francis Indowa, Secretary General, National Gun Coalition, and the National Gun Coalition Party itself. The plaintiff asked this court firstly to interpret sections 41, 75, and 76 of the 1991 Constitution of Sierra Leone. Interpretation of those constitutional provisions will help determine 1. Whether a naturalized citizen of Sierra Leone is disqualified from being elected as a member of parliament and thereby also disqualified to be elected president. 2. Whether a citizen of a country other than Sierra Leone, having become one voluntarily or otherwise, in brackets, or is under a declaration of allegiance to such a country, is disqualified from being elected a member of the Sierra Leone parliament and consequently disqualified to be elected president. 3. If the answer to question 1 is in the affirmative, what is the effect in law of a naturalized citizen running for election as a member of parliament and consequently for the office of president? 4. If the answer to question 2 is in the affirmative, what is the effect of such a citizen running for parliament and also for the office of president? Secondly, the plaintiff posed for determination by this court the interpretation of sections 5 and 7 of the Sierra Leone Citizenship Act 1973 as amended by Act number 11 of 2006. First question posed was whether upon a proper construction of sections 10 of the Section 10 of the 1973 Act as amended, and before the coming into force of the Amendment Act in 2006, a person having Sierra Leone citizenship and any other citizenship as one at the same time by operation of law ceased to be a Sierra Leonean. 2. Whether upon a proper interpretation of Section 11 of the 1973 Act as amended and before the coming into effect of the 2006 Amendment Act, a person upon attaining the age of 22 years, being a citizen of Sierra Leone and also a citizen of another country by operation of the law, ceased to be a citizen of Sierra Leone. 3. The answer to question 1. The answer to question 1 is in the affirmative. Can such a person be eligible to contest parliamentary and presidential elections? 4. If the answer to 2 is in the affirmative, what is the effect in law of a person who is already a citizen of Sierra Leone and also a citizen of another country? Can such a person be eligible to contest parliamentary and presidential elections? The plaintiff sought the following declarations. 1. That by virtue of sections 41, 75, and 76 of our 1991 Constitution, no person shall be qualified to be elected a member of parliament or president if he is a naturalized citizen of Sierra Leone. 2. That by virtue of sections 41, 75, and 76 of our Constitution, no person shall be so qualified to be elected a member of parliament or president if he is a citizen of a country other than Sierra Leone, having become such a citizen voluntarily or is under a declaration of allegiance to the other country. 3. that by virtue of sections 10 and 11 of the 1973 Act as amended, and before the coming into force of the 2006 Amendment Act, a citizen of Sierra Leone who was also a citizen of another country ceased to be a Sierra Leonean. And 4, that if the declarations sought above are granted, the first defendant, Dr. YUMKELLA, is disqualified to be elected a member of Parliament or President. The motion was supported by the affidavit of the plaintiff himself, deposed to also on 5th February 2002. Since the plaintiff withdrew the action, or was given leave to withdraw the action, rather, I shall not dwell on all the matters deposed to therein. I shall only set out and comment on those which may assist this court in making the declaration sought impliedly by the first defendant and expressly by the seventh defendant. The plaintiff deposed that he was a businessman and also a registered voter. He did not declare his citizenship whether by birth or by naturalization. In this respect, his action would have failed in any event because Section 47, Subsection 2 of the Public Elections Act 2012 stipulates that the person taking objection to the nomination of a presidential candidate should himself be a citizen of Sierra Leone. He exhibited his voter identification card, which does not necessarily and by itself prove that he is a citizen of Sierra Leone. He goes on to depose to certain matters of a legal nature, which he says are based on what he was told by his lawyers. One such was that prior to the 2006 Amendment Act, Sierra Leone did not recognize dual citizenship, and that by virtue of their own amended 1973 Citizenship Act, any person who had attained the age of 22 years ceased automatically to remain a Sierra Leone citizen if he held the citizenship of another country. Another matter I deposed to is that certain persons may have ceased to be Sierra Leone citizens by becoming citizens of another country, and that these persons were not eligible to be elected members of Parliament. He admits that he is aware that the first defendant was born in Sierra Leone and that the first defendant has been in possession of the country's passport over the years. He goes on to depose that he was informed and that the first defendant had himself admitted that he had become a naturalized citizen of the United States of America and had been issued with a United States of America passport. He was aware that first defendant was the flag bearer for the National Grown Coalition and also a parliamentary candidate for the same party. He admitted in his paragraph 16 that it is public knowledge that the first defendant had said at a press conference that he had renounced his United States citizenship so as to comply with the 1991 Constitution. He deposes further that he was informed by one Abu Bakr Sanko, whom he verily believes that he, the said Sanko, had taken objection to the candidacy of first defendant in the Cambia constituency 62 for the parliamentary election on the ground that first defendant held dual nationality, but that Sanko's objection had been ignored by the returning officer in Cambia. To further his inquiries about the first defendant's status, he wrote to the Minister of Internal Affairs asking whether first defendant had resumed his Sierra Leonean nationality. He was informed by the ministry that it had no record of first defendant resuming his nationality. He was not satisfied that first defendant had truly renounced his American citizenship. First defendant had not provided any proof of his renunciation of American citizenship, nor of his resumption of Sierra Leone citizenship. In his paragraph 24, he deposes that, to quote him, that I honestly believe the only reason why the first defendant has not produced his certificate of loss of nationality is because it does not in fact exist, and therefore his claim of renunciation of U.S. nationality is incorrect. I have quoted this particular paragraph verbatim as it has some bearing on the point in time when the plaintiff realized that in truth, first defendant had indeed renounced his U.S. citizenship. This also has a bearing on the issue of costs, notwithstanding plaintiff's withdrawal, being granted leave to withdraw his action subsequently. These facts deposed to by the plaintiff formed the basis for instituting the action hearing. On 12 February 2018, the plaintiff swore and deposed to a further affidavit. To that affidavit, he exhibited as DF5 a copy of the letter he had received from the Ministry of Internal Affairs. That letter reads, quote the letter, I refer to your letter dated 19th January 2018 on the above subject matter. We have conducted a search of our records and can confirm that ALHAJI Dr. KANDEH YUMKELLA has not availed himself, as put by you, to, I think this should be off, the provisions of the Sierra Leone Citizenship Act, Sierra Leone Citizenship Amendment Act number 11 of 2006 to resume Sierra Leone citizenship. Furthermore, our record do not show, I'm quoting the letter, do not show any compliance with the conditions precedent as contained in the Sierra Leone Citizenship Amendment Act No. 13 of 1976 or any other provision, legal or otherwise, in this regard. End of quote. In that letter, the minister did not explain why he had concluded that the first defendant had lost Sierra Leone citizenship and why he, the first defendant, needed to resume the same. In any event, it is the view of this court that the minister may have acted outside the law. No application was made to him on the Access of Information Act 2012. He, as a public officer, though not in public service, in terms of Section 170, subsections 1 and 4 of the 1991 Constitution, was therefore bound by the oath of secrecy attached to the public office he held. He may have come close to contravening the provisions contained in Section 7, subsection 1 of the Treason and State Offences Act 1963. Section 7, subsection 1 states, inter alia, if any person having in his possession or control any document or information which has been entrusted in confidence to him by any person holding an office established by the Constitution, or a public office, or which he has obtained or to which he has had access owing to his position as a person who holds or has held any such office as aforesaid, or as a person who holds or has held a contract made on behalf of the government, or as a person who holds or has held any such office or contract, A, communicates the document or information to any person other than a person to whom he is authorized to communicate it, or a person to whom it is in the interest of the state his duty to communicate it, shall be guilty of an offense. The minister had no right to disclose the information of a private nature to any individual requesting him to do so in a personal and private capacity. The plaintiff has repeatedly stressed his independence from any political leanings. He has not said he was a public officer, nor anyone to whom it was necessary to communicate official information for official purposes. He had no right to the information he requested. The minister also had no right to respond to his request for information. If he had or has that right, then a person in his position or in an equivalent position is equally entitled to disclose information of a confidential nature to anyone who requests him to disclose the same. In his letter to the minister, the plaintiff did not state that he was requesting the information for official purposes. Disclosing official information for private purposes has serious consequences. As such, the minister was not obliged to disclose the same to him. I shall return to this issue later in this judgment. Further, to show how wrong the minister was, he certainly did not advert his mind to the Passport Act 1964, Act number 49 of 1964, as amended by Section 7 of the Interpretation Act Interpretation of 1971, and by the Passports Amendment Act 1974, the latter adding on a new Section 8. Section 2 of the 1964 Act states, Section 2, subsection 1, the President, acting in accordance with the advice of the Minister of Foreign Affairs and International Cooperation, formerly Minister of External Affairs, may issue a passport in the existing form or such other form as he may prescribe by notice in the Gazette to any person who is a citizen of Sierra Leone. Subsection 2, where any person has either A, renounced his citizenship, or B, been deprived of his citizenship other than by order made under the provisions of the Sierra Leone Nationality and Citizenship Act 1962, since repealed by Section 28 of the 1973 Citizenship Act, his passport shall be withdrawn from him. The plaintiff did not suggest or contend at any point in time that first defendant's passport had been withdrawn from him. Neither did the minister in his letter to the plaintiff assert the same. On the contrary, the evidence available in the affidavit and statement of case of the first defendant shows that his passport has been renewed successively since 1980. Section 28 of the 1973 Citizenship Act also amended the relevant provisions in Section 1 of the Non-Citizens (Registration, Immigration and Expulsion Act 1965, Section 1 of the Non-Citizens Trade and Business Act 1969, and Section 4 of the Interpretation Act 1971, where the definition of native for the purposes of the Act is given. Further, the definition of native in the 1971 Act has been further amended by Section 3 of the 1976 Citizenship Act. The plaintiff deposed further to the state of the law in the United States relating to the naturalization process and what it entails, principally the renunciation of the nationality originally possessed by the applicant for naturalization. This rationalization is made notwithstanding that in his first affidavit he had deposed that he knew the first defendant was born in Sierra Leone, which automatically made him a Sierra Leonean citizen by birth, a Sierra Leonean by birth. What he did not depose to was the state of the law in Sierra Leone relating to what renunciation of citizenship really means for a citizen by birth. The fact that the first defendant's name did not appear on any list prepared by the United States of America department responsible for naturalization matters has no bearing on the state of the law in Sierra Leone. Further, there is a principle in international law and expressed in our citizenship laws that a person should not be rendered stateless intentionally. This is a matter I shall return to later. On 15 February 2018, the plaintiff filed a statement of case in accordance with the rules of this court. In view of the plaintiff's subsequently request to withdraw his case, and in view of the seventh defendant's application that this court should make two of the declarations set out in his statement of case, only two submissions in the plaintiff's statement of case merit attention. Page 9, paragraph C, subparagraph 2, subparagraph B, the plaintiff submits as follows. That is ALHAJI against the Secretary of State for the Home Department, 2016 England and Wales Court of Appeal reports, page 1136, reiterates the point that citizenship, how one becomes a citizen, how one loses his citizenship, how one is an alien, is a matter of law with regards to the law of citizenship, in this case in Sierra Leone, and not with reference to any other document, not even holding a passport. He continues further in subparagraph 2, subparagraph C, as follows. We will submit on the basis of the submissions above, the first defendant can only be deemed a citizen or non-citizen, or be deemed to have lost his citizenship, or be deemed to now be a Sierra Leonean in accordance with what the citizenship laws of Sierra Leone expressly prescribe, and not with reference to any other fact. These two subparagraphs succinctly set out what the plaintiff's complaint is all about. It is our view, and as I have stated in the opening paragraphs above, that our Sierra Leone Citizenship Act 1973, as amended in 1976, 2006, and finally in 2017 by Act number 3 of 2017, sets out the position clearly and requires no interpretation. It stipulates how one loses one's citizenship and how one regains it. The minister's letter exhibited by the plaintiff to his second affidavit was inaccurate in the conclusion reached therein. It was clearly tendentious and made without proper consideration of the law in question. It follows that contrary to the submission made by the plaintiff in subparagraph 2, subparagraph Q, at the same page 9 of his statement of case, it was not the duty of the third and fourth defendants to open an inquiry as to the current status of the first defendant once he had provided the appropriate responses required in the schedule to the Public Elections Act 2012. Making a false statement in the declaration for nomination is punishable as perjury. That would have been a matter for a person taking objection to first defendant's nomination as a candidate. For that matter, plaintiff has not, in all of the documents filed on his behalf, himself provided proof of his citizenship. He has merely exhibited his voter identification card. That is not by and in itself proof of citizenship. It follows also that the conclusions reached by the plaintiff at subparagraph 3, subparagraphs A and B on pages 9 and 10 of his statement of case are insupportable as of January 2018. The state of the law as to citizenship in January 2018 was, as is stated in the 1973 Act as amended in 1976, in 2006 and 2017 respectively. In his conclusions reached, the plaintiff conflated the meaning of ceasing to be a citizen and the renunciation of citizenship as one and the same thing. Ceasing to be a citizen is a passive act. You may have ceased to be one because of something you may have done or not done. But renouncing one's citizenship requires something to be done by both the person concerned and some other authority connected with the act of renunciation. If the further arguments advanced by the plaintiff in his subparagraph 3, subparagraph E and F, subparagraphs E and F are taken to their logical conclusion, it would mean that the first defendant, having ceased to be a Sierra Leonean citizen for all purposes and for all time by taking on American citizenship, would automatically become stateless once he relinquished or renounced his American citizenship. There is provision in our laws to prevent such an unfortunate consequence. In their haste Both the plaintiff and the Minister of Internal Affairs at the time omitted to advert their respective minds to this provision. In any event, and in order to provide clarity, one cannot in the nature of things cease to be a citizen by birth under Sierra Leone law. This has been clarified by the 2017 amendment to the 1973 Act. One can properly deny the circumstances of his birth. One can, however, renounce an adopted nationality or citizenship, a citizenship conferred by either naturalization or registration, or one transmitted to that person by one or both of his birth parents. The Australian case to which reference will be made below illustrates why, under Australian law, an Australian citizen could still be considered ineligible for election to that country's parliament because of the transmission to that person of foreign nationality through one or both of his parents. On 1st March 2018, the first defendant filed a statement of case. In this pleading, the first defendant sets out in detail the reasons why the plaintiff's action should fail. First, he avers that he is a citizen by birth and by descent of Sierra Leone. Second, he admits that he had in 1995 acquired citizenship of the United States of America by naturalization. He effectively renounced that citizenship in November 2017, well before the nomination process for the 2018 elections began in January 2018. He had held a press conference to announce his renunciation to the whole world. As such, the fact of his renunciation of American citizenship was a matter well known, or must have been well known, to plaintiff. The plaintiff had earlier in his affidavit admitted that he was aware of the press conference and what transpired at that event. The main contention in the first defendant's statement of case is that the proceedings were unnecessary. There was a laid-down procedure for persons wanting to challenge the candidacy of an individual who wished to contest either election. That procedure could be found in the Public Elections Act 2012. As such, the plaintiff's action amounted to an abuse of the jurisdiction of this court. I have dealt with this aspect of the case above, and that in view of this court's decision in the Dr. Silver Biden and others case, the plaintiff could only have come to this court by way of an originating notice of motion. On 19th March 2018, first defendant deposed and swore to his affidavit in opposition to the plaintiff's motion. This was done with leave of the court. There is no express provision in the Supreme Court Rules 1982, Statutory Instrument of 1982, for the filing of an affidavit in opposition by a defendant. Rule 92, Sub-Rule 2, Paragraph A, speaks of an affidavit verifying the facts, particulars, documentary or otherwise, contained in the defendant's statement of case. But in order to aid our deliberations, we allowed the first defendant to do this. In his affidavit, first defendant narrated his ancestry, then how he became a citizen of the United States of America and how he renounced his citizenship of that country before being nominated as a parliamentary candidate and as a candidate in the presidential election in 2018. He exhibited to that affidavit copies of his birth certificate, his current Sierra Leone passport, his voter identification card, his certificate of loss of American nationality, together with his oath/affirmation of renunciation of American nationality and his nomination certificates for the parliamentary and presidential elections respectively. Exhibited also are copies of the decisions taken by the Cambria District Returning Officer and by the fourth defendant on objections raised to his candidature in both elections. The last exhibit is a copy of a document issued by the United States of America government setting out the steps to be taken in renouncing American nationality. The second defendant, though represented at the hearings by State Counsel, did not file a statement of case. The third and fourth defendants filed a joint statement of case through their solicitors on 27 February 2018. A solicitor in the firm, Mr. Duxel Taylor, on the same day deposed and swore to an affidavit verifying his client's joint statement of case. Several documents are attached to that statement of case, including Sierra Leone Gazette number 12, published on Tuesday, 30th January 2018, setting out the names of parties and of their respective candidates for the expected presidential election on 27th March 2018. The statement of case filed by these defendants contains that the proper procedure for registering candidates for the presidential election was followed to the letter, and that the plaintiff has not adopted the proper procedure to contest the first defendant's eligibility to contest that election. As they did not seek any declaration from this court, I need not dwell further on the other issues raised in their joint statement of case, save to say that at the hearing on 29th March 2018, Mr. Taylor, counsel for both third and fourth defendants stated that the reason they had contested the plaintiff's claim was because in paragraph 10 of the plaintiff's statement of case, the plaintiff had alleged that the third and fourth defendants had been incompetent in the way they had handled the plaintiff's objection to the first defendant's nomination as a presidential and as a parliamentary candidate. Clearly, as the plaintiff has withdrawn the case, has been given leave to withdraw the case against all defendants, the result is that the allegation is unfounded and remains unproven. In any event, as will be shown later in this judgment, the third and fourth defendants were quite right in the way the objections to the first defendant's candidature were dealt with. On 1st March 2018, pursuant to an order made by the court, leave was given to the 5th, 6th, and 7th defendants to file respective statements of case out of time. This was done pursuant to powers conferred on this court by Rule 89, Sub-Rule 5 of the Supreme Court Rules 1982. They were to be filed against 2 p.m. the following day, that is Friday, 2nd March 2018. The statement of case was on the 2nd of March 2018 filed on behalf of both 5th and 7th defendants. The 6th defendant did not file any. On the 2nd March 2018, counsel for the 6th defendant, Mr. Sulaiman Banjo Tijansi II, applied for the recusal of Justices Solomon and Matthew Jones, respectively. Both justices recused themselves the following Monday, that is 5th March 2018. The Honorable Chief Justice was requested to replace both justices. The court was reconstituted the following day, Tuesday, 6th March 2018, with Justices Alusain Sise and Sengo Koroma joining the panel of justices. A further extension of time was given for the 6th defendant to file a statement of case against 19th March 2018, and for any other defendant to file an amended statement of case against that date. Likewise, the plaintiff was given leave to file a reply, if necessary, against 21st March 2018. Hearing was then adjourned to 28th March 2018. I must state for the record, and as explained above, that the court was forced to depart from the strict rules of filing because of the exigencies of the situation. The presidential election and also the parliamentary, city and local council elections, respectively, were due to be held and were held on Tuesday, 7th March 2018, the day after the court hearing. No candidate was able to gain 55% of the votes cast, and a runoff as required by law was fixed for Tuesday, 27th March 2018. The interlocutory orders granted by this court will not therefore necessarily be granted in future cases in the absence of such exigencies. Further, another challenge to the holding of the runoff election had to be heard by this court in the presence of myself, Justice Roberts, and Justice Thompson, Justices of the Supreme Court. That is Supreme Court case Miscellaneous Application 1 of 2018, National Electoral Commission, and another against Ibrahim Suri Kuruma. Judgment was delivered 2 days ago on 4 September 2021. But with the swift action taken by this court in that case, the holding of the runoff would have been frustrated by just a single individual. Pursuant to leave granted as stated above, the 7th defendant on 19th March 2018 filed its statement of case dated 16th March 2018. The 7th defendant is the political party the first defendant belongs to, and under whose banner he contested the presidential election held on 7th March 2018. It reprises the case filed by the first defendant, and there is no need to set it out here. It has been mentioned specifically because the 7th defendant's counsel, Ms. Jushu Sharif, has applied, as she was entitled to do, for a declaration to be made by this court in terms of paragraph 4 of that statement of case. It reads, Paragraph 4. The 7th defendant submits that the question of the meaning and effect of sections 10 and 11 of the Sierra Leone Citizenship Act 1973 as amended, although of no direct relevance and interest to the first defendant in this particular case, and even though now repealed, is indeed of great moment and concern to the 7th defendant, which is a political party with obligations to promote and protect the rights and interests of its membership, whether in and out of Sierra Leone, and to the entire nation. The 7th defendant thus invites his honorable court not only to refuse to make the declaration each sought in the plaintiff's originating notice of motion dated 5th February 2018, but to rather declare that, to quote Ms. Jushu Sharif, any person who upon attaining the age of 22 years was or is a citizen of Sierra Leone and also a citizen of another country did and does not by operation of law or any other means cease to be a Sierra Leonean. In this respect, the declaration sought by the 7th defendant is related not only to the provisions of the citizenship laws, but also to the interpretation to be given to Section 76, Subsection 1, Paragraph A of the 1991 Constitution, specifically that portion which reads as follows, for the provision, or is a citizen of a country other than Sierra Leone, having become such a citizen voluntarily, or is under a declaration of allegiance to such a country. The first defendant is clearly a citizen of Sierra Leone by birth, as the documents exhibited to his affidavit and to his statement of case clearly show. It is not therefore necessary to embark on an excursus into the eligibility to contest presidential elections of one who is a citizen by naturalization. Section 124, Section 1 of the Constitution states, the Supreme Court shall, as otherwise provided in Section 122 of this Constitution, have original jurisdiction to the exclusion of all other courts, A, in all matters relating to the enforcement or interpretation of any provision of this Constitution. Section 122, Subsection 1, confers appellate jurisdiction on this court and does not concern us here. However, Section 122, Subsection 3 does. It states, for the purposes of hearing and determining any matter within its jurisdiction and the amendment, execution, or the enforcement of any judgment or order made or any such matter, and for the purposes of any other authority expressly or by necessary implication given to it, the Supreme Court shall have all the powers, authority, and jurisdiction vested in any court established by this Constitution or any other law. As indicated in paragraph 40 above, Section 124, Subsection 1 should be read subject to Section 122, Subsection 3. The general original jurisdiction is conferred in Section 124, Subsection 1, but that constitutional provision does not go further to stipulate how the jurisdiction could be exercised. There was no need for that, as that had already been done in Section 122, Subsection 3. Further, Section 145 of the Constitution established the Rules of Court Committee and sets out its purpose. Subsection 145(1) of established the committee, and subsection 145, subsection 2 sets out its duties as follows. Subject to the provisions of this Constitution, the Rules of Court Committee may make rules of court for regulating the practice and procedure of all courts in Sierra Leone, which shall include rules relating to the prevention of frivolous and vexatious proceedings. The rules governing practice and procedure in this court are the Supreme Court Rules 1982, made pursuant to the now repealed 1978 Constitution of Sierra Leone. By reason of the transitional provisions contained in subsection 175 of the 1991 Constitution, these rules still apply in this court. Rule 89 is the principal rule and sets out the manner in which the original jurisdiction should be invoked. It should be by originating notice of motion supported by an affidavit setting out, among other things, the relief sought. The plaintiff's statement of case could be filed at the same time as the motion, but in any event not less than 10 days after the filing of the motion. Rule 92 states that if the defendant upon whom the motion has been served wishes to contest the case, he too must file a statement of case within 10 days or such further time as the court may allow. The statement of case shall contain inter alia the facts and particulars verified by affidavit which the defendant seeks to rely on. The parties may agree, or the court may order them to file a memorandum of agreed issues. Rule 97 sub Rule 1 is relevant to the request made by counsel for the seventh defendant for a declaration to be made in seventh defendant's favor. It states, Rule 97 sub Rule 1, the court may, after considering the statement of the plaintiff's case and of the defendant's case, the memorandum of agreed issues and any arguments of law, decide to determine the action and give judgment in court on a fixed date without argument on the appointed time at which the parties shall appear before the court for further hearing of the action. It is the view of this court that notwithstanding the application for withdrawal of the plaintiff's case at the stage where arguments were due to commence, this court has jurisdiction to determine the action brought by the plaintiff in terms of the declaration sought by the seventh defendant in his statement of case. It is, as it were, the seventh defendant's counterclaim. Rule 98 states, when a provision is expressly made in these rules relating to the regional and the supervisory jurisdiction of the Supreme Court, the practice and procedure for the time being of the High Court shall apply mutandis. Other than the general pronouncement in Rules 97 sub Rule 1 set out in paragraph 44 above, there is no specific rule in the Supreme Court rules dealing with the situation where the plaintiff applies for withdrawal from the litigation after filing his statement of case, but where a defendant at the same time seeks judgment in terms of his statement of case. This court had to invoke Order 24 of the High Court Rules 2007 in order to permit the plaintiff to withdraw his claim. That rule states as follows. Rule 24, Sub-Rule 3, Paragraph 1. Except as provided by Rule 2, a party may not discontinue an action, whether begun by writ or otherwise, or counterclaim, or withdraw any particular claim made by him in the action or counterclaim without the leave of the court, and the court, hearing an application for the grant of such leave, may order the action or counterclaim to be discontinued, or any particular claim made in it to be struck out as against any or all of the parties against whom it is brought, or made on such terms as to cost the bringing of a subsequent action, or otherwise as it thinks just. The seventh defendant has applied for its claim, so to speak, to be decided by this court, and this court thus has the jurisdiction to do so. The case of Supreme Court Case Number 1/2002, Daniel Sanko against the President Ahmed Tijan Kaba, shows that this can be done. There, the plaintiff filed his originating notice of motion and did nothing further. The defendant had filed a statement of case in answer to the plaintiff's claim in the motion. The court held that it had jurisdiction to hear and determine the case on the basis of the defendant's statement of case. Likewise, in the Republic of Gambia, the Supreme Court has taken the same stance. The rules governing appeals and original action in the Supreme Court are in very similar terms. One of the cases in which the issue of what should happen when a party to the litigation in the Supreme Court withdraws or abandons its statement of case is the Supreme Court Criminal Appeal No. 11 of 2014, Joseph Wowo against the state, which was heard by Mr. Justice Jallo, Chief Justice, myself, Mr. C.S. Jallo, Mrs. Justice C, and Mr. Justice Njai, Justices of the Supreme Court. Judgment delivered on 23rd November 2017 by myself. There I said at paragraph 34, page 25 of the judgment of the court, I shall end by recording for posterity that when the appeal came up for hearing during the May-June sittings, Ms. Drame appeared for the appellant and Mr. Abubakar appeared as counsel for the respondent. Ms. Drame relied on the statement of case filed by the appellant's original counsel, Mr. Achigwe. Mr. Abubakar sought leave and was granted leave by this court on 5th June 2017 to file the respondent's statement of case out of time. But when the appeal came up for hearing the following day, that is on 6th June 2017, Mr. Abubakar surprisingly informed the court that he wished to withdraw the respondent's statement of case. The court granted him leave to do so. On reading through the statement of case, it was clear that considerable thought and research had been put into it, but the court could not but accept Mr. Abubakar's application. Thereupon, Ms. Drame asked that the appellant's convictions be quashed. This court took the view, and rightly so, that the withdrawal of the respondent's statement of case did not amount to a command to this court to set aside the appellant's convictions. This court has made it's clear in another case decided during the May-June sittings that even where a respondent states that he or she no longer wishes to defend the judgment of the court below or to go on with prosecuting his or her case, when the original jurisdiction of this court is invoked, this court will have to decide such case on its merits once it has become seized of it. The earlier case referred to in that judgment was Civil Suit Supreme Court 3 of 2016, Usain Udabo and 19 others against the Inspector General of Police, the Director of National Intelligence Agency, and the Attorney General. The case was heard by Mr. Jallo, Mr. Justice Jallo, Chief Justice, Justice Yaya, myself, Mr. Justice C.S. Jallo, and Justice C, Justice of the Supreme Court. The judgment was delivered on 29th May 2017 by the Honorable Chief Justice, Mr. Justice Jallo. The learned Chief Justice of the Gambia, at page 2 of his judgment, had this to say after the Attorney General in person had applied to the court for leave to abandon the statement of case filed on behalf of his predecessor in office. The Chief Justice said, this court takes judicial knowledge of the fact that in January 2017, there was a change of government in the Gambia. When the case came up for hearing before the full court on 26 May 2017, the new Attorney General, Abubakar Tambadu, appearing in person on behalf of the other defendants, indicated to the court that the defendants had wished for the matter to be resolved other than through litigation, in view of what the learned Attorney General described as the public commitment of the new government to uphold the rights and freedoms of the citizens. The learned Attorney General stated that the defendants have determined that they can no longer defend the position taken by the defendants prior to the change of government. That as a result, the defendants wish to abandon the statement of case in this suit, that for the avoidance of doubt, the defendants admit that the prayers sought by the plaintiff are in accordance with the relevant provisions of the Constitution. In short, the defendants are no longer contesting the claims of the plaintiffs. Their request to abandon their statement of case is granted, and the statement is accordingly struck out. The learned Attorney General is commended for his candor in declining to defend a case he believes to be indefensible. In view of the admissions of the defendants, Mr. Antoman Gay, learned counsel for the plaintiffs, has urged the court to enter judgment for his clients. In the ordinary civil suit, that would probably be the consequence of no contest by the defendants and by the admission of the plaintiff's claims. But this is no ordinary case. It is a case where the constitutional validity of legislation is being challenged by the plaintiffs. The legitimacy of the exercise of the legislative power is being questioned. The court is being urged. Sorry, I think I'll stop. I think I've missed out. I'll replace it. That's his paragraph from. That's towards the end of paragraph 52. I'll continue paragraph 53. Now, our constitution does not confer an immediate referral duty on our president. What it does is to provide in the proviso to section 122, subsection 1 as follows. Notwithstanding any law to the contrary, the president may refer any petition in which he has to give a final decision to the Supreme Court for a judicial opinion. All the same, in the name of the national interest of the country, it would seem that it would have been more appropriate for either the presidency or at least the third defendant, the second defendant, the country's Attorney General and Minister of Justice, to have brought up this all-important issue for the determination by this court. The Attorney General and Minister of Justice was the third defendant in these proceedings, but remained mum by not filing any statement of case and by not instructing counsel who appeared on his behalf to say anything one way or the other. To do so apparently by proxy through the plaintiff hearing may not have served the country's best interests. I use the expression by proxy advisedly, as the plaintiff says he is a paid-up member of his party, which held the presidency and the majority in our parliament. This led to Mr. Sharif applying for the court to allow, as amicus curiae, the Human Rights Commission to participate in these proceedings so as to represent the public interest. Other jurisdictions have had cause over the years to deal with this thorny issue of the effect of dual nationality on one's chances of becoming a representative of the people. There are two cases from Kenya I'll refer to. The first is election petition 15 of 2008, Mahmoud Muhammad Sirat against Ali Hassan Abdirahman and two others. 2010 Electronic Kenya Law Reports. It's a High Court decision. The first respondent claimed that the petitioner was not a Kenyan citizen, he having renounced his citizenship in order to acquire Australian citizenship. The court was asked to interpret section 35, subsection 1 of the Kenya Constitution. It provides that no person shall be qualified to be elected a member of the National Assembly inter alia if at the time of his nomination by virtue of his own act he is under an acknowledgement of allegiance, obedience or adherence to a foreign state. Section 97(1) of the Kenya Constitution is also couched in similar terms as the now repealed section 11 of the 1973 Act. That is the provision which speaks to a citizen ceasing to be one when on attaining the age of 22 years he is still the citizen of another country. As stated before, in our jurisdiction, that obnoxious provision was repealed in 2006. At page 7 of the electronic version of the judgment, Mr. Justice Kimaru had this to say about the two Kenya provisions referred to above. My reading of sections 88, 90, 92, 93, 94, 95, and 97 of the Constitution leads me to the conclusion that the said sections of the law prohibited persons of a particular category who are citizens of other countries at the time of Kenya's independence. It does not apply to citizens of Kenya who acquired citizenship by virtue of their birth from acquiring citizenship of another country after attaining 21 years of age. The said sections of the Constitution must be read in the context by which they were enacted. At the time Kenya attained independence, certain category of persons who qualified to acquire Kenyan citizenship and having the option of retaining British citizenship were being subtly encouraged to decide whether they desired to be citizens of the newly independent Kenya or be subject to the United Kingdom and colonies. Even assuming that the petitioner had indeed acquired Australian citizenship, there is nothing in the Constitution that specifically prohibits the petitioner from acquiring such citizenship while at the same time retaining his Kenyan citizenship, provided that Australian law allows for its citizens to acquire and have dual citizenship. There is only one exception This is where the petitioner specifically renounces the citizenship of Kenya and acquires citizenship of another country that does not allow dual citizenship. The first respondent placed no evidence before this court that establishes that the petitioner has renounced his citizenship of Kenya as contemplated by Section 97, Subsection 7 of the Constitution. The plaintiff therein failed to do the same. The plaintiff hearing, failed to do the same. He failed to provide evidence to show first defendant had indeed renounced Sierra Leone citizenship at any point in time. As the learned judge pointed out in his judgment, the prohibition in the Kenya Constitution, similar to Sections 10 and 11 of the 1973 Act, does not automatically prohibit a citizen by birth from acquiring the citizenship of another country after attaining the age of 21 years. A citizen by birth would only theoretically lose the citizenship by birth of a country if the country whose citizenship he seeks to acquire requires it. And that could only be done in this jurisdiction after the procedure laid down in Section 15 of the 1973 Act has been followed, so that the person concerned does not become stateless. The second Kenyan case is that of Civil Appeal 280 of 2013 Bishop Donald Kisaka against the Attorney General and Electronic Kenya Law Reports Court of Appeal. The case was presided over by Githingi, Wasame, and Karaoke Justices of Appeal. I must point out at the start that the 2010 Kenya Constitution recognized dual citizenship, unlike the 1963 Constitution. In that case, the appellant Bishop Kisaka was a citizen by birth of Kenya. He subsequently acquired the United States citizenship and thus became a dual citizen. The case concerned the interpretation to be given to several provisions in the 2010 Kenya Constitution, in particular Articles 99, 78, 137, and 148 thereof, and Section 22(1) of the Elections Act 2011. The 2010 Kenya Constitution recognized dual citizenship. Dual citizenship was also recognized in Section 8, Subsection 1 of the Kenya Citizenship and Immigration Act 2011. At page 8 of the electronic version of the judgment, the Court of Appeal held inter alia, the recognition of dual citizenship by the new constitution is a bold milestone and a progressive one, considering that many countries, even the developed countries, are reluctant to allow dual citizenship. It is a measure of our understanding and recognizing the peculiar circumstances that prevail in our legal regime. This is a timely nod to our own legislature. At page 10 of his judgment, the Kenya Court of Appeal had to say, Section 22(1) of the Elections Act provides that a person may be nominated as a candidate for election under the Act only if that person is qualified to be elected to that office under the Constitution and the Act. The learned judge relied on that provision and Article 78(2) for the finding that a dual citizen is not qualified for nomination as a candidate for an election. This was an erroneous finding, for as observed above, the prescription is not against a dual citizen vying for election, but against a dual citizen holding a state office. That is a point which was missed by the learned trial judge. We think that was a fundamental error. In order to deal comprehensively with this issue of who is eligible in terms of Section 76, Subsection 6, Paragraph A of our 1991 Constitution to contest presidential elections, I must now turn my attention to the cases in our jurisdiction dealing with the eligibility of a candidate to contest parliamentary or local elections. I shall start with Tubeke against Bayo. It's in 1957 to 60 African Law Report Sierra Leone Series 72. It's a judgment of the West African Court of Appeal. The judgment was delivered by Mr. Justice Ames, acting Chief Justice of the Gambia. The issue there was to determine on whom the burden should lie where one party alleges that another is not eligible to contest local council elections on the ground that the person was an alien, that is, not a Sierra Leonean. The court held that the burden lay on the person who was claiming to be eligible as the matter lay peculiarly within his own knowledge. The appellant's appeal was therefore dismissed. He claimed he was a Sierra Leone citizen holding the passport of a British protected person, but could not otherwise prove that he had been born in Sierra Leone. Bayo later sought leave to appeal against that decision to the Privy Council on the ground that the matter was of public importance. Mrs. Justice Mark, later Mr. Justice Ivy, acting Chief Justice, in dismissing the application, was unimpressed about the point, remarking at page 1 of his judgment that it is difficult to conceive how the question whether the applicant is a British subject merely because he is in possession of a British passport can be a matter of any interest to any person other than the applicant. Mr. Justice Bayramian, the Chief Justice, and Justice Luke concurred in the result. The next was James Thomas Refun against the Queen, 1963, Volume 3 of the Sierra Leone Law Reports, page 102, Court of Appeal. The court was presided over by Mr. Justice Ames, acting President, Mr. Justice Dob Edwin, Justice of Appeal, and Mr. Justice Mark, Judge. The issue there was whether Mr. Refu was an alien within the meaning of Section 15 of the Freetown Municipality Act, Chapter 65 of the Laws of Sierra Leone 1960, and as such not qualified to contest the city council elections. In October 1962, an alien was one who was neither a citizen of Sierra Leone nor a British subject. Mr. Refu was charged in the High Court with perjury in that he had made a false declaration in his nomination paper, to wit, that he was qualified to contest the council elections. At the trial, the prosecution alleged that he was a Liberian citizen. He was convicted and appealed against his conviction to the Court of Appeal. In giving judgment for the court, Mr. Justice Ames had this to say at page 107. In our view, this passport had no probative value in this case. It does not state the appellant to be a Liberian national. There was no evidence before the court of law in Liberia concerning the issue of passport, whether only issued to their own nationals and what proof is required, and so on. The passport states that the appellant was born at Buchanan, which was assumed to be in Liberia. There was no evidence to that effect. So he may have been a Liberian national at birth. If his parents were not such, he may have had dual nationality at birth. But one cannot be helped by what may have been. Liberian law as to nationality had to be proved as a fact, and there was no evidence on the point. Mr. Justice Russell said in Stoke v. Public Trustee, Volume 2 of the Chancery Reports for 1921, page 67, and at page 82, which was cited by Mr. Macaulay for the respondent, whether a person is a national of a country must be determined by the municipal law of that country. Upon this, I think all text writers are agreed. End of quote. In the result, the court adjudged that Mr. Refu had not made a false declaration during the nomination process and was not therefore guilty of perjury. The learned trial judge should have upheld a no-case submission made on his behalf. Mr. Refu's appeal was allowed. The important point made here is that one's citizenship at any particular point in time must be determined by the local law and not by the law of any other country. I shall return to this point when dealing with Section 15 of the 1976 Act. 1970 Act, I beg your pardon. I will now turn my attention to the case of Aka against the Attorney General, 1967 to 68, African Law Report Sierra Leone series, page 283. As the High Court, the decision was delivered by the Honorable Basa Banjo Tijansi, Chief Justice. And then in the Court of Appeal, at page 381, judgment delivered by Sir Samuel Banco, Jones President. And the further appeal to the Privy Council, which is reported in the 1968 to 69 volume of the African Law Reports Sierra Leone series, page 274. The judgment of the court was delivered by Lord Morris of Bothigest. The issue there was whether the 1961 Constitution, which conferred citizenship on the plaintiff, John Joseph Aka, who was of mixed African Lebanese parentage, could be taken away by a subsequent act of parliament. Under Section 1 of the 1961 Constitution, Mr. Aka was considered a citizen by birth of Sierra Leone. The Constitution was amended by the Constitution Amendment Act 1962, Act number 11 of 1962, and the Constitution Amendment number 2 Act 1962. That was Act number 12 of 1962. These acts took away Mr. Aka's right to citizenship. These two acts were preceded by Act number 10 of 1962, passed the same day, 17th March 1962. That was the Sierra Leone Nationality and Citizenship Act 1962. In the High Court, Mr. Justice Chijansi, Chief Justice, held that he had not been so deprived of his citizenship and that the purported amendment of Section 1 of the 1961 Constitution by Acts numbers 11 and 12 respectively of 1962 were otherwise the 1961 Constitution and therefore null and void. The Court of Appeal took the opposite view and reversed the High Court decision. It reasserted the primacy of the legislature to pass legislation which could deprive one of vested rights. Mr. Aka then took his case to the Judicial Committee of the Privy Council. The Judicial Committee agreed unanimously, Lord Guest dissenting on just one issue, with the reasoning and judgment of Mr. Justice Tijansi, Chief Justice, and allowed Mr. Aka's appeal. It would have been seen that the 1961 Constitution of Sierra Leone, as amended, made specific provision for citizenship. But when we attained Republican status in 1971, the Constitution of Sierra Leone 1971 and the Constitution of Sierra Leone number 2 1971 were silent on this issue. The whole issue was finally addressed once more in the Sierra Leone Citizenship Act 1973. Section 2 of the Sierra Leone Citizenship Act 1973 provides as follows. Every person who having been born in Sierra Leone before the 19th day of April 1971 or who was resident in Sierra Leone on the 18th day of April 1971 and not the subject of any other state shall on the 19th day of April 1971 be deemed to be a citizen of Sierra Leone by birth, provided that A, his father or his grandfather was born in Sierra Leone, and B, he is a person of Negro African descent. On the evidence provided, first defendant was clearly a person of, was and is a person of Negro African descent. He was born to Sierra Leone and parents in Sierra Leone in 1961, and as of 19th April 1971, was deemed a Sierra Leone citizen by birth. Therefore, he did not need to go through the process of naturalization. Part 3 of the 1973 Act did not therefore apply to him. Section 5 of the 1973 Act was repealed and replaced by the 2017 Act, Act number 3 of 2017. This Act was given the presidential assent on 6th July 2017. Section 5 now states, that is Section 5 of the 1973 Act as amended, now states, every person born outside Sierra Leone on or after the 19th day of April 1971, of a father or mother who was or would, but for the death of the person, have been a citizen of Sierra Leone by virtue of Sections 2, 3, and 4, is a citizen of Sierra Leone by birth. The importance of the 2017 amendments cannot be underestimated. It clarifies for all time that one can be a citizen by birth of Sierra Leone even though one was born abroad. Section 10 of the Act states, no person shall have Sierra Leonean citizenship and any other citizenship at one and the same time. In 2006, the Sierra Leone Citizenship Amendments Act, Act number 11 of 2006, repealed and replaced this provision as follows. A citizen of Sierra Leone may hold a citizenship of another country in addition to the citizenship of Sierra Leone. In 2006, therefore, it was permissible for the first defendant to hold the citizenship of Sierra Leone and that of the United States of America. Section 11 states, any person who upon attaining the age of 21 years is a citizen of Sierra Leone and also a citizen of another country shall cease to be a citizen of Sierra Leone upon his attaining the age of 22 years, and in brackets, or in the case of a person of unsound mind at such later date as may be prescribed, unless he has complied with paragraphs A, B, and C of Section 9. The first defendant reached the age of 21 years in 1982. According to the uncontradicted evidence before us, he acquired American citizenship by naturalization in 1996 when he was over 35 years of age. He therefore did not become a dual citizen at the age of 21 years. He may have become so in 1995, but by 2006, this was permissible by virtue of the 2006 Act. In any event, Section 11 was repealed by Section 9 of the Act number 11 of 2006 and is no longer law in Sierra Leone. It follows that 11 years before first defendant declared his intention to contest the presidential election in Sierra Leone, he was entitled to hold dual citizenship. Part 5 of the 1973 Act applies to the first defendant as well. He was a citizen of Sierra Leone and ipso facto a citizen of the Commonwealth. Part 6 does not apply to the first defendant. He was never a citizen of Sierra Leone by naturalization or registration. He was always a citizen by birth. And I turn my attention to Section 15 of the 1973 Act. I shall quote it in full. Section 15, subsection 1. When a citizen of Sierra Leone who is of full age and capacity makes a declaration renouncing his citizenship of Sierra Leone, the minister shall, if he is satisfied that the person is unceasing to be a citizen of Sierra Leone, will become a citizen of a Commonwealth country or the Republic of Ireland, or B, a national of a foreign country, cause the declaration to be registered, and thereupon that person shall cease to be a citizen of Sierra Leone, provided that the minister may withhold registration of such declaration if he is satisfied, 1, that the person is ordinarily resident in Sierra Leone, or 2, that the person has acquired such rights or interests in Sierra Leone as the minister considers to be inconsistent with an alien nationality, or 3, that the registration will otherwise be contrary to the public good. For the purposes of this section, any woman who is or has been married shall be deemed to be of full age and of full capacity if she is not of unsound mind. This is the only way it can be said that a citizen of Sierra Leone has lost his citizenship and therefore ceased to be a citizen of Sierra Leone. There's not a scintilla of evidence, to quote the Honorable Dr. Abdullah Conte, lead counsel for the first defendant, that any minister of government, including the author of the letter of 31st January 2018, exhibited as DF5 to the plaintiff's affidavit, did any of the things he was supposed to do in the event that the Sierra Leone citizen renounced his citizenship. And there is certainly no evidence that first defendant renounced his Sierra Leone citizenship and or nationality in the manner prescribed in the state statutory provision. Further to what I have stated above, for some inexplicable reason, the plaintiff has proceeded on the basis that first defendant renounced his Sierra Leonean citizenship. He has not explained in his affidavit nor in his statement of case how he came to this conclusion. He has not stated that it is a requirement of the citizenship laws of the United States that in order to acquire its citizenship by naturalization, the applicant should first renounce his original citizenship. And for that matter, Sierra Leone does not require such renunciation before conferring citizenship by naturalization. As I have pointed out already, public policy and the express provisions of Section 15 of the 1973 Act require that an individual should not be rendered stateless by state authorities. Thus, the express provisions in paragraphs A and B of Section 15, subsection 1. The plaintiff is therefore quite wrong in the quick conclusions he has reached in paragraphs 33, 34, 35, and 36 of his second affidavit, deposed and sworn to on 12th February 2018. As to whether first defendant did renounce his American citizenship, his exhibits KKY4 and KKY5 respectively provide clear evidence of this. KKY4 is a copy of his certificate of loss of American nationality, and KKY5 is a copy of his oath of renunciation of his American nationality. Both documents support his paragraph 14, where he poses that he formally renounced his American citizenship on 22nd November 2017, well before allowing his name to go forward for nomination of election to the office of president. The researches allegedly conducted by the plaintiff as deposed to in paragraphs 40 to 44 of his second affidavit are of no moment when put side by side with the first defendant's certificate of loss of nationality. The bold assertion made by the plaintiff in his paragraph 48 that first defendant was not in fact a Sierra Leonean in 2005 is also unfounded and is in fact untrue. First defendant never relinquished or renounced his citizenship in the manner prescribed by Section 15 of the 1973 Act. In paragraph A, subparagraph 5 of his statement of his first defendant through his counsel has averred, among other things, that, to quote the first defendant, but he, first defendant, always carried a Sierra Leonean passport and manifested keen interest in the socio, economic and political processes of his native land. End of quote. First defendant's most recent passport was exhibited to his affidavit of 19th March 2018 as KKY2. Plaintiff has not in any way refuted this averment. It seems to this court that whatever may have been plaintiff's conception or misconception of or about first defendant's status, he was duly notified of the same as of 19th March 2018 at the latest. But it was only on 28th March 2018, 9 days thereafter, that he finally considered in his affidavit in support of his motion to discontinue the action that first defendant had duly renounced his citizenship of the United States. His action was in truth unnecessary. The notice of discontinuance bearing date 22nd March 2018 but filed on his behalf on 23rd March 2018 was ineffective, as we ruled at the time, to discontinue the action he had begun. Counsel for the seventh defendant, the NGC, has stated the reasons why, notwithstanding the plaintiff's discontinuance of his case, the National Grand Coalition is seeking the declaration referred to above. This is understandable. In the first place, the Supreme Court is not the proper forum for challenging the eligibility of candidates for parliamentary elections. Also, where objection is taken to the eligibility of a candidate for a presidential election, the proper method is set forth in clear terms as explained in paragraphs 3 to 9 above. There is no real need to deal with this here. The focus is on the declaration sought by the seventh defendant, a declaration well within the remit of this court. The clear and unambiguous answer to the question posed by counsel for the seventh defendant is that the person does not cease to be a citizen of Sierra Leone just because upon attaining the age of 22 years, he had obtained or subsequently obtained the citizenship of another country. Section 41 of the 1991 Constitution deals with the eligibility of a candidate for the presidential election. He should be a citizen of Sierra Leone. He should be a member of a political party. He should have attained the age of 40 years. First defendant met these criteria. The fourth criterion is that he should otherwise be qualified to be elected as a member of parliament. This criterion is tied to Section 75 and 76 of the Constitution. It clearly met the criteria laid down in Section 75. Section 76, subsection 1 states as follows: no person shall be qualified for election as a member of Parliament, A, if he is a naturalized citizen of Sierra Leone or is a citizen of a country other than Sierra Leone, having become such a citizen voluntarily, or is under a declaration of allegiance to such a country. The first defendant was and is a Sierra Leonean by birth and never lost that right. He was not and is not a naturalized citizen. He did voluntarily become a citizen of the United States of America in or around 1995. He gave up that citizenship in November 2017. As of January 2018, he was no longer a citizen of the United States of America. He was therefore qualified for election as a member of Parliament. He was qualified to contest the presidential election. Further, he could only be asked to vacate his seat in Parliament or would become ineligible to continue to occupy his seat in Parliament if, according to Section 77, subsection 1, paragraph D of the 1991 Constitution, he ceases to be a citizen of Sierra Leone. This specific provision throws open for argument the issue of whether a member of Parliament, elected as such, at a time when he held dual nationality, could be asked to vacate his seat for that reason, though he continues to hold Sierra Leone citizenship. It seems to me that he could not, so long as he continues to hold Sierra Leone citizenship. Though possessor of dual nationality, he would be qualified in terms of Section 77, subsection 1, paragraph G of the 1991 Constitution to be registered as an elector for the election of members to Parliament. There is no disability attached to dual nationality for the purpose of being eligible as an elector under the Public Elections Act 2012. Lastly, this court has been invited by counsel for all the defendants to address the issue of costs. This is clearly not a public interest litigation. This action was started by the plaintiff on his own. Matters of public interest have been canvassed before in this court. A case in point is Palmer against the governor, 1950-56, African Law Report, Sierra Leone 6, page 258. It's a High Court case. The judgment there was delivered by Mr. Justice Lucius Smith, Chief Justice. There, Mr. Palmer, then commonly known as Bombas Palmer, sued the governor, claiming that certain legislation passed by Her Majesty the Queen by way of the Sierra Leone Legislative Council or in Council 1951 was invalid and could not be applied in Sierra Leone. The action was lost because, according to Mr. Justice Smith, Chief Justice, at page 261 of his judgment, the governor should not have been sued as such. He should have been sued in his own name. Mr. Palmer did not stand to gain anything personally from the litigation. He thought the order in council was unlawful. No order for cost was made by the learned Chief Justice, but Mr. Palmer was not dissuaded by this defeat. He brought another action, this time around against the governor in his own name, but seeking the same relief. The case is Palmer against Truk and the Attorney General, 1950-56, African Law Reports, Sierra Leone Series 284. The judgment again was delivered by Mr. Justice Smith, Chief Justice. Mr. Palmer lost again, and the Chief Justice, Justice Smith, made no orders to costs. Mr. Palmer's appeal against that decision to the West African Court of Appeal was again dismissed at pages 325 to 330 of the same volume of reports. This time around, however, costs were awarded against him, such costs to be taxed. Counsel for the defendants have implored this court to award punitive costs against the plaintiff. Their main contention collectively is that the action was bound to fail for the reasons stated in this judgment. In their view, it was brinkmanship of the worst kind. In this respect, counsel for the first defendant and also counsel for the seventh defendant, Ms. Jushu Sharif, cited to us the relevant case law authority. She cited Chukulingo against the Law Society of Trinidad and Tobago, 1978, page 30, West Indian Reports, volume 13, West Indian Reports, page 372, a judgment of the Court of Appeal. And also Myers and Ellman, volume 4 of the All England Reports for 1939, page 484, a House of Lords decision. We have considered these authorities, but this court has come to the conclusion that whatever may have been the fault of counsel for the plaintiff, he intimated this court of his instructions to withdraw the action as soon as he was so instructed. He did not procrastinate or prevaricate. He may have been mistaken as to the law, as we have pointed out above, but he ought not to be punished for that. The business of counsel is to present and to argue his case based on the instructions he has received. It is for this reason that the court has made reference to Palmer's respective cases in the High Court and in the West African Court of Appeal. Counsel for the plaintiff in those matters, Mr. Otudurin and Mr. Ronald Biokubets, were well-respected lawyers in the day, but they brought an action which was bound to fail. The first time around, because no action was maintainable against the governor in his official capacity. In the second case in the High Court, Mr. Justice Smith, Chief Justice, at page 294, lines 5 to 7, describes Mr. Palmer's case as follows. It is clear, therefore, that the plaintiff's first claim is quite hopeless and should not be allowed to proceed further. At page 95 of the same report, the learned Chief Justice had this to say about Mr. Palmer's second claim. The claim is too vague one and does not allege any unlawful act, and I hold, therefore, that the claim has no hope of success. At the end of his judgment, the Chief Justice had this to say at page 297, lines 4 and 5. I dismiss the action summarily. There will be no orders to cost. This court believes that it should follow the reasoning of the learned Chief Justice as to the substance of the plaintiff's claim in that action, but should differ on the issue of cost. We are of the view that the plaintiff was well aware of the first defendant's status before he gave instructions to his counsel. He should therefore bear the cost of the action up to the date he applied to discontinue the action. In the result, the seventh defendant's declaration is granted. 1. This honorable court declares and orders that any person who, upon attaining the age of 22 years, was or is a citizen of Sierra Leone and also a citizen of any other country, did and does not, by operation of law or any other means, cease to be a Sierra Leonean. 2. The plaintiff shall bear the cost of the action up to the date he applied for it to be discontinued in favor of the first, third, and fourth defendants. The fifth and sixth defendants were joined at the instance of the first defendant. The second defendant did not participate actively in the action and is not therefore entitled to costs. Justice Roberts.
Thank you, ma'am. My lords and my ladies, I've had the benefit of reading the judgment of my brother Brown Mark JSC. I agree with and adopt his summary of the facts of this case, his identification of the issues for determination, counsel. I also agree with his final declaration on orders. The extent that my consideration of the issues may well be in addition to. Permit me to give my judicial opinion, albeit the following summary of the relevant and salient filings and applications in this action for clarity and ease of reference. By an originating notice of motion dated 5th February 2018, one David FORNA, the plaintiff in this action, sought, among others, an interpretation of sections 41, 75, and 76 of the Constitution of Sierra Leone, Act number 6 of 1991. By the determination of several questions contained in the said originating notice of motion. He also prayed for several declarations, which I do not find necessary to reproduce here, as in any case he has applied to discontinue the action. The sole declaration that warrants further consideration will be dealt with later in this judgment. The originating notice of motion is supported by several affidavits by David FORNA with exhibits attached. In the originating notice of motion, the plaintiff named. Thank you. In the originating notice of motion, the plaintiff named ALHAJI Dr. KANDEH YUMKELLA as the first defendant, the Attorney General as the second defendant, Mohammed Ali Conte as the third defendant, and the National Electoral Commission as the fourth defendant. An application was made for Dr. Dennis Bright, Chairman and leader of the National Grand Coalition, Francis Hindowa, Secretary of the NGC, and the NGC party to be added as parties to this action. By order of this court made on the 2nd of March 2018, the aforementioned were added as 5th, 6th, and 7th defendants respectively. Statement of case was filed on behalf of each defendant. After adjournments for further hearings, the plaintiff filed a motion dated 28 March 2018, praying that the action against all the defendants be discontinued and or in the alternative, that leave be granted for the withdrawal of the action. An affidavit in opposition filed by Yasmin Beindu Sando Jusu Sheriff on behalf of the defendants. At the hearing of the application for its continuance, Dr. Abdullahi Conte of counsel for the first defendant stated that he was not opposing the application, noting that Dr. Yumkella's status was made known to the plaintiff long ago, and he was therefore asking for costs. Notwithstanding the affidavit in opposition, Yasmin Jusu Sharif said she was not opposed to the application. She, however, referred to the originating notice of motion as well as the statement of case of the seventh defendant and asked this court to make the following declaration. To wit, and I quote, "Any person who upon attaining the age of 22 years was or is citizen of Sierra Leone and also a citizen of any other country did and does not by operation of law or any other means cease to be a Sierra Leonean." ISCLR of counsel for the fifth defendant said he was not opposed to the application for discontinuance, noting, however, that the fifth defendant suffered financial loss as a result of the institution of this action by the plaintiff. Counsel stated that supporters who were supposed to have given funds withdrew at the last minute because of the uncertainty this action created. D. Taylor of counsel for the third and fourth defendants also said he was not opposed to the application. At this stage, it became clear to me that apart from procedural issues which have been dealt with in the judgment of Brownmark, there were two main issues for consideration by this court. The first is the application for discontinuance by the plaintiff, and the second is the declaration sought and urged by counsel on behalf of the seventh defendant. I shall deal with them in the order they have been mentioned here. Indeed, there is no express provision in the Supreme Court Rules 1982 for the discontinuance or withdrawal of an action commenced by originating notice of motion. However, by virtue of Rule 98 thereof, this court is authorized to use the relevant practice and procedure in the High Court, and it is by this authority that Order 24 of the High Court Rules 2007 relating to discontinuance becomes applicable. I note that the plaintiff in his application prayed for, and I quote, that the action herein be discontinued and in the alternative that leave be granted to the plaintiff for the withdrawal of the said matter. End of quote. In my view, discontinuance usually refers to where the party wishes to abandon the whole or entire action, while withdrawal refers to abandonment of a part or a claim in his action. Indeed, the plaintiff in his affidavit in support of the application deposed, again I quote, "I have now instructed my solicitors to discontinue the action." End of quote. It would only be proper, therefore, for the application to be treated and considered as one for discontinuance. Having read the application and having heard counsel for plaintiff and defendants respectively, I do not find any reason or reasons why the application should not be granted, especially so when counsel for the defendants have stated that they are not opposed to it. I therefore join my brethren in granting the application, save for the consideration of the declaration sought and urged by the seventh defendant, which I shall now turn to. Following the plaintiff's application for discontinuance of his case, the defendants accepted and did not in the main oppose it. Counsel for the seventh defendant, however, sought and urged the declaration stated above. On careful perusal of this declaration sought, I find its wording rather curious. For a start, it seeks a declaration on a state that can no longer exist in law by virtue of the Citizenship Act No. 4 of 1973, that is the 1973 Act, as amended by the Citizenship Amendment Act No. 11 of 2006, hereinafter called the 2006 Amendment Act. In other words, I beg your pardon, in order to appreciate the purport of the declaration sought and to underscore how irrelevant its consideration may be, I will reproduce here relevant sections of the 1973 Act as well as the 2006 Amendment Act. Section 10 and 11 of the 1973 Act states as follows: "No person shall have Sierra Leone citizenship and any other citizenship at one and the same time. 11. Any person who, upon attaining the age of 21 years, is a citizen of Sierra Leone and also a citizen of another country, shall cease to be a citizen of Sierra Leone upon his attaining the age of 22 years, or in the case of a person of a sound mind, at such later date as may be prescribed, unless he has complied with paragraphs A, B, C of Section 9. The above sections are no longer in force. Section 10 has been repealed and replaced by Section 5 of the 2006 Amendment Act as follows. And Section 5 of the Amendment Act reads, Section 10 of the Principal Act is repealed and replaced by the following section. 10. The new 10. A citizen of Sierra Leone may hold a citizen of another country in addition to his citizenship of Sierra Leone. And Section 11 of the 1973 Act was repealed by Section 9 of the Amendment Act as follows. 9. The new 9. Sections 6, 11, and 23 of the Principal Act are hereby repealed. Prior to the 2006 amendment, the law prohibited dual citizenship where a citizen of Sierra Leone voluntarily acquired the citizenship of another state as provided in the Act. But this is no longer the case by virtue of Section 5 of the 2006 Amendment Act. And the Sierra Leonean can now hold dual citizenship. The law regarding a Sierra Leonean holding dual citizenship does not therefore require any further elucidation. However, the plaintiff in argument had suggested that before the passing of the Amendment Act in 2006, Dr. YUMKELLA had gained U.S. citizenship and had thereby lost his Sierra Leone citizenship. I do find this argument rather spurious and dated, if not disingenuous. Apart from the general purpose of the 2006 Amendment Act, Section 7A thereof, which amended Section 19 of the 1973 Act, provides for the resumption of Sierra Leonean citizenship in situations where a citizen might have lost his citizenship by virtue of, among others, acquiring a foreign citizenship. And it would be useful to note that notwithstanding the reference to citizenship by naturalization in Section 16 to 18 of the 1973 Act, the amendment, Section 19A, clearly refers to, quote, a citizen of Sierra Leone, end quote, and does not limit its application to citizenship by naturalization. In the light of the above and by virtue of the 2006 amendment, there is no doubt that dual citizenship is permitted under the laws of Sierra Leone and that Dr. YUMKELLA never lost his Sierra Leone citizenship. It must be made clear that Dr. YUMKELLA has shown uncontroverted evidence to this court that in fact he does not hold dual citizenship, having renounced his U.S. citizenship since November 2017. This was indeed admitted by the plaintiff in his affidavit in support of his application for discontinuance of this action. There is, however, an interesting issue of whether a Sierra Leonean holding another citizenship may be disqualified from being president of Sierra Leone. Whilst this issue remains a matter of public interest, it is not one that remained in the list of issues for consideration by this court. I say this because the parties to this action no longer urged for its dissemination. Firstly, the plaintiff has applied to discontinue the whole of his action, which includes the issue of whether a dual citizenship may be disqualified to contest for Member of Parliament or President of Sierra Leone. On the part of the defendants, particularly Dr. YUMKELLA, his renouncing his U.S. citizenship since 2007 renders a determination of whether a dual citizen is qualified to contest for Parliament and Presidency an academic and rather speculative exercise, one that was criticized by Dr. Abdullahi Conte of Counsel for Dr. YUMKELLA. However, having had the benefit of reading the judicial opinions of my brethren in this panel, I note a significant mention by some and consideration by others of the issue of whether a dual citizen may be qualified to contest for Parliament or the Presidency. It is perhaps for this reason that I deem it useful to make my contribution as may be helpful in the circumstances. My first, but no less telling observation, is that all the parties to this action support or are of the view that by virtue of Section 76(1)(a) of the 1991 Constitution, a dual citizen is disqualified from contesting as a Member of Parliament. Indeed, the plaintiff in paragraph D of his originating notice of motion sought a declaration to that effect. Also, the first defendant, Dr. YUMKELLA, agreed that by virtue of Section 76 of the Constitution, a dual citizen was disqualified from contesting as a Member of Parliament. This is evident in Dr. YUMKELLA's statement of case and his affidavit in support of his case as shown below. In paragraphs Roman 10 and Roman 11 of his case, filed on the 19th of March 2018, Dr. YUMKELLA submitted as follows. 10. Quote, he formally renounced his American naturalization in November 2017 at a ceremony in the Embassy of the United States in Freetown. At the conclusion of the renunciation ceremony, the first defendant requested and was formally handed a certificate of loss of American citizenship, CLN. The first defendant believes that from the date of his renunciation of his American citizenship in November 2017, he became compliant with all the provisions of the National Constitution of 1991 and the laws of Sierra Leone governing eligibility to vote and elected to the public political office, including as a Member of Parliament and the office of President of the Republic. Also, in a transcribed recording of an address by Dr. YUMKELLA at a press conference in January 2018, which is exhibited as DT3 in the affidavit of David FORNA in support of the originating notice of motion, Dr. YUMKELLA is recorded as stating as follows. Thus, voluntarily and because of my firm commitment to serve my country, I renounced my U.S. citizenship to ensure that I fully qualified to run for Parliament on behalf of the people of Samoa and to contest the position of the President of Sierra Leone. In other words, I made sure that I did not violate Section 76, Subsection 1A of the 1991 Constitution. From the above, it is evident that the parties, both the plaintiff and particularly the first defendant, hold the view that Section 76(1)(a) of the Constitution, that by Section 76(1)(a) of the Constitution, a dual citizen may be disqualified from contesting as a Member of Parliament. Notwithstanding the sealing agreement by the plaintiff and the first defendant on the effect of Section 76(1)(a), it will be prudent to record my consideration of the issue having regard to the existing law. Section 76(1)(a) of the Constitution provides as follows. No person shall be qualified for election as a Member of Parliament, A, if he is a naturalized citizen of Sierra Leone or is a citizen of a country other than Sierra Leone, having become such a citizen voluntarily or is under a declaration of allegiance to such a country. This provision is, in my view, clear, precise, and unambiguous. It has not been amended or repealed. The 2006 amendment did not also affect Section 76(1)(a) of the Constitution, whether by express mention or reference, nor by implication or construction. In the case of Chanrai and Co. Limited against Palmer, 1970-71, All African Law Reports, Sierra Leone Series, page 391 at page 405, Lipsiluke CJ had this to say, and I quote, in my judgment, if the words used in a statute are plain and unambiguous, the court is bound to construe them in their ordinary sense, having regard to the context. End of quote. This dictum of Lipsiluke CJ was cited with approval and indeed adopted by Toller Thompson GSC in SC number 2, 2005, the case of Samuel Hinga Norman against Dr. Samar S. Banya and others. I adopt same, and I find no reason, to give any other meaning apart from its plain and ordinary meaning. For the avoidance of any doubt, however, it will be useful to record that Section 76(1)(a) does not automatically disqualify all and every holder of dual citizenship from contesting membership of Parliament. What the provision disqualifies are the following. Firstly, a naturalized citizen is disqualified from the election to Parliament. Second, a citizen by birth, for example, may only be disqualified for election as Member of Parliament if he voluntarily becomes a citizen of another country or is under a declaration of allegiance to such other country. A relevant issue that may be raised here is one posed by my brother Brown Mark in his judgment when he asked, and I quote, whether a Member of Parliament elected as such at the time when he held dual nationality could be asked to vacate his seat for that reason, though he continues to hold Sierra Leone citizenship. I agree with him that such a member may not automatically vacate his seat so long as he continues to hold Sierra Leone citizenship, and I adopt his reasons given in support of that view. I will say no more on this issue, primarily because in truth it was no longer one of the issues for consideration by this court following the plaintiff's continuation of the action. Furthermore, it would have been helpful had arguments and submissions been made by a person in that situation, i.e. a member with dual nationality. Let me conclude by returning to the sole declaration now sought by the seventh defendant. I concur in granting it as in the judgment of Brown Mark JSC. The plaintiff's action is accordingly discontinued. I also agree with his orders as to costs, such costs to be taxed if not agreed. It's working now.
My lords, I have had the advantage of reading the speech of my learned brother Brown Mark JSC, and with the exception of his conclusion that Section 47 of the Public Elections Act 2012 PEA is inconsistent with Section 126 of the 1991 Constitution, and the necessity for acceding to the request of the seventh defendant to make the declaration sought, I agree with his judgment, and I gratefully adopt the facts as set out by him and other issues, including those relating to costs. I have considered with care my brother's discourse and findings in respect of the conflict between the PEA and the 1991 Constitution of Sierra Leone. This is self-evidently an important issue, and one that should be clarified by this court in order to provide certainty and clarity in respect of an important aspect of electoral law. Having considered the matter, I take a contrary view to my brother, and I am satisfied that there is no conflict between Section 47(3) of the PEA 2012 and the 1991 Constitution. The starting point when considering the potential conflict between an Act of Parliament and the Constitution is the presumption of regularity. Parliament must be taken to have been cognizant of the relevant provisions of the Constitution when enacting the PEA, and must be taken to have satisfied itself that the provisions of the PEA would not require this court to do anything which was contrary to its constitutional authority. As is often stated, it is for Parliament to legislate and for this court to interpret legislation in a manner that is consistent with the will of Parliament and compatible with our Constitution. Section 47 of the PEA deals with the publication of the nominations of presidential candidates. Section 47(3) states that, and I quote, an objection against the nomination of a presidential candidate shall be heard by the Supreme Court, made up of 3 justices, whose decision shall be given within 30 days of the lodging of the objection, end of quote. It is obvious that in enacting this provision, Parliament recognized the fundamental importance of ensuring that there is an efficient and speedy mechanism for resolving disputes concerning presidential nominations which would not frustrate the election process, whilst at the same time providing a safeguard for potential candidates. This is reinforced by Section 47(4), which states that, and I quote, "Where the Supreme Court upholds an objection against a nomination, it shall declare the presidential candidate concerned to be disqualified from contesting the presidential election." End of quote. The authority and limits of this court are to be found in Chapter 7 of the Constitution. Section 121 deals with composition of the court and stipulates that there should always be a minimum of 5 justices of the Supreme Court, one of which must be the Chief Justice. There is no maximum number of justices that is required. The business of the Supreme Court is regulated by Section 1212, which states that, and I quote, "The Supreme Court shall, save as otherwise provided in paragraph A of subsection 6 of Section 28 and Section 126 of the Constitution, be duly constituted for the dispatch of its business by not less than 3 justices thereof." End of quote. It follows that, save for the exceptions mentioned in Section 28(6) and Section 126, the minimum number of justices required for the court to be quorate is 3. Section 1213 provides that, and I quote, "The Chief Justice shall preside at the sittings of the Supreme Court, and in his absence, the most senior of the justices of the Supreme Court, as constituted for the time being, shall preside." End of quote. The fact that Section 47(3) of the PEA states that the Supreme Court shall be made up of 3 justices for the purposes of hearing an objection to a nomination cannot be said to be inconsistent with Section 1213 of the Constitution, unless it infringes Section 28(6) or Section 126 of the Constitution, to which I shall return. The court's jurisdiction is set out in Section 122, which explicitly states inter alia at subsection 1 that the court, I quote, "shall have such appellate and other jurisdiction as may be conferred upon it by this Constitution or any other law." End of quote. The court's powers are extensive and include appellate, Section 123, interpretive, Section 124, supervisory, Section 125, interlocutory, Section 126, and the enforcement powers, Section 127. In other words, its powers are not just confined to those conferred upon it by the Constitution, other legislation. It follows that it also therefore includes the jurisdiction conferred upon it by the PEA 2012. I now return to Section 28(6) of the Constitution. Section 28 deals with the enforcement of protective provisions. Those provisions are set out in Sections 16 to 27. They are not fully rehearsed here, but include the right to life, protection from arbitrary arrest or detention, protection from slavery and forced labor, and protection from inhuman treatment, the right to fair trial, and protection from discrimination. Significantly, in the context of this matter, elections, whether parliamentary or presidential, do not fall under the protected provisions. That when this court is dealing with a referral that concerns any of the protected provisions, it shall consist of, and I quote, "not less than 5 justices," end of quote. And the court is required to pronounce its decisions in open court not later than 30 days after a referral. Section 47 of the PEA is not caught by Section 28(6) of the Constitution, and therefore there can be no inconsistency between the two. I now turn to Section 126 of the Constitution. This section sets out the powers of this court when exercising its interlocutory jurisdiction. It states, and I quote, "A single justice of the Supreme Court acting in its criminal jurisdiction and 3 justices of the Supreme Court acting in civil jurisdiction may exercise any power vested in the Supreme Court not involving the decision of a cause or matter before the Supreme Court, save that A, in criminal matters, if any such justice refuses or grants an application in the exercise of any such power, any person affected thereby shall be entitled to have the application determined by the Supreme Court constituted by 3 justices thereof, and B, in civil matters, any order, direction or decision made or given by the 3 justices in pursuance of the powers conferred by this section may be varied, discharged or reversed by the Supreme Court constituted by 5 justices thereof. End of quote. Section 47.3 of the PEA 2012 is civil, not criminal. However, before considering the impact of Section 126 of the Constitution on it, we must first determine whether an objection brought under Section 47.3 is an interlocutory matter. I observe in passing that Section 126 is an exception to the requirements of Section 1212, because it permits the business of the court to be conducted by a single judge instead of 3 when dealing with interlocutory criminal matters. Under the PEA 2012, the jurisdiction for determining an objection against the nomination of a presidential candidate is conferred upon the Supreme Court. If the court upholds the objection, then this is decisive of the issue, and the court must then declare the presidential candidate concerned to be disqualified from contesting the presidential election pursuant from Section 47.4 of the PEA 2012. It follows from the above that in dealing with an objection under 47.3 of the Supreme Court, under 47.3 with an interlocutory matter, but is acting in accordance and in furtherance of the jurisdiction expressly conferred upon it by the PEA 2012 as permitted by Section 1221 of the Constitution, and as such, its decision is final. Notwithstanding that this is not an interlocutory matter, it is clear that when dealing with such matters, there can be no question of inconsistency or incompatibility unless 3 justices are empaneled to deal with a matter concerning a protective provision. The fact that a decision by a panel of 3 may be varied, discharged or reversed by a panel of 5 reflects the fact that an interlocutory matter is not decisive of an issue and allows for the matter to be revisited before the issue at hand is finally determined, if there are compelling reasons to do so. Our Constitution is not unique in this regard. By virtue of Section 1281 of the 1992 Constitution of Ghana, the Supreme Court consists of the Chief Justice and not less than 9 justices. This is the equivalent of our own Section 1211. The equivalent of our 1212 is Section 1282, which states that the Supreme Court is, and I quote, duly constituted for its work by not less than 5 Supreme Court justices, except as otherwise provided by Article 3 of this Constitution, end of quote. Section 133 is a provision of review of its own decisions, a provision which we do not have in our own Constitution. However, Section 134 is the equivalent of our Section 126. A single justice of the Supreme Court may exercise power vested in the Supreme Court not involving the decision of the cause or matter before the Supreme Court, end of quote. Save that in criminal matters, a dissatisfied litigant may go before a panel of 3 justices, the same as for our civil matters, where the decision may be varied, discharged or reversed as the case may be. Similarly, in Kenya, Constitution of Kenya 2010, the Supreme Court consists of the Chief Justice, the Deputy Chief Justice, and 5 other justices. See Section 1631. Section 1632 is the equivalent of our Section 1212. The Supreme Court is properly constituted for the purposes of its proceedings if it's composed of 5 judges. It is therefore indisputable, in my view, that an application under Section 47.3 of the PEA falls within the jurisdiction of this court. It follows that the requirement in the section for 3 justices to make a decision within 30 days is entirely consistent and compatible with Section 1212 of the Constitution. For the purposes of the electoral calendar, speedy and efficient disposal of our applications and challenges are extremely important. This is not inconsistent with the ruling of this court in the case of Dr. Sylvia Blyden, Dr. Samura Kamara and others, numbers 6 of 2008 and 7 of 2008, that the route to invoking the original jurisdiction of the Supreme Court is by originating notice of motion. The fact that the Supreme Court will state that the filing should be done within 10 days does not mean that parties should wait until the 10th day to file. In cases where urgency is required, the court would expect parties, and where applicable the court, to have served the relevant documents well before the time limit for service expires, and in any event not later than the 10-day limit. It is the case that in the recent past, including in this case, this court has departed from its laid down rules on time when the urgency of the situation demanded it. When the court is dealing with a matter which by law it needs to rule upon within 30 days, then time limits will be strictly enforced so that the court has at most 10 days to consider and deliver its ruling. The issue here is not the process, but rather the substance of the relevant and applicable sections. I shall now turn to the matters raised by the parties, and I shall confine myself to the following. A, the plaintiff's reason for withdrawal of his action, as stated in his affidavit sworn to on the 28th March 2018 and attached to his notice of motion. B, the request by the seventh defendant to determine the order prayed for in paragraph H of the plaintiff's originating notice of motion, regardless of his motion for withdrawal, and section 76(1)(a) of the Constitution of Sierra Leone 1991. Notice of motion for withdrawal. It is clear that the purpose and objective of this action was as stated in paragraph I of the orders prayed for in the originating notice of motion dated 5th February 2018. That is the disqualification of the first defendant. Rather than simply file an objection as prescribed in section 42 of the PEA, the plaintiff sought to take a circuitous route, thereby wasting valuable court time and costs in this process. The reason stated by the plaintiff for seeking to discontinue the matter in his affidavit sworn to on the 28th of March 2018, which supports the notice of motion for discontinuance of the same date, is that he is now satisfied that the first defendant had renounced his US citizenship and was therefore qualified to stand in the parliamentary and presidential elections. Accepting as we must that the plaintiff is now genuinely satisfied that the issue of whether the first defendant had renounced his citizenship, which is a question of fact that does not require the Constitution to be interpreted, it follows that the action brought by the plaintiff is at best ill-conceived and at worst frivolous and vexatious. It is clear that the plaintiff did not need the court's interpretation of the various sections of the Constitution and the Sierra Leone Citizenship Act 1973 as amended when he filed his originating notice of motion dated 5th February 2018. The inescapable reality of the plaintiff's stance is that either he had no difficulty interpreting the relevant provisions of the Constitution, or that on realizing that the first defendant was no longer a US citizen, he had an epiphany, the result of which was that he was suddenly enlightened about the various sections he needed interpreted. Either way, it demonstrates that the action as filed was wholly without merit. It ought not to need stating that the courts in general, and this court in particular, should not be used as a political weapon in order to achieve political gain. The rule of law and an effective democracy require strong and independent institutions, of which this judiciary is and must be seen to be one. The court must therefore guard against attempts to abuse its process for the sake of political expediency, disguised as an application for interpretation. It will not have escaped the attention of most right-thinking people that the very topic of this action, nationality and citizenship, was toxically divisive and menacing at a time when national cohesion and good citizenry was most important. It hardly needs stating that this country's recent history ought to inform the conduct of those seeking political office. The determination of paragraph H of the plaintiff's originating notice of motion. The defendants have all stated in open court that they are not averse to the discontinuance subject to costs. The second defendant, though represented, made no representations, nor was any case filed on his behalf. However, the seventh defendant has asked that, given the importance of the matters raised, the court should determine the order prayed for in paragraph H of the plaintiff's originating notice of motion and make a declaration as follows, I quote, "Any person who upon attaining the age of 22 years or is a citizen of Sierra Leone and also a citizen of any other country did and does not by operation of law or any other means cease to be a Sierra Leonean," end of quote. This declaration is sought despite the fact that Section 10 of the Sierra Leone Citizenship Amendment Act 2006, the 2006 Act, repealed Section 11 of the 1973 Act. Section 11 of the 1973 Act stated as follows, I quote, "Any person who upon attaining the age of 22 years is a citizen of Sierra Leone and also a citizen of another country shall cease to be a citizen of Sierra Leone upon his attaining the age of 22 years, or in the case of a person of unsound mind, at such later date as may be prescribed, unless he has complied with paragraph A, B, and C of Section 9, end of quote. For ease of reference, Section 9 deals with citizenship by naturalization. Section 10 of the 2006 amendment reads as follows, I quote, "A citizen of Sierra Leone may hold the citizenship of another country in addition to his citizenship of Sierra Leone," end of quote. As stated above, this amendment repeals the aforementioned Section 11 of the 1973 Act. Counsel for the seventh defendant, however, urged this court to deal with the issue because the seventh defendant is a political party, I quote, "with obligations to promote and protect the rights and interests of its membership, whether in or out of Sierra Leone, and to the entire nation," end of quote. As a matter of law, where there is an act of parliament that changes previous legislation, unless the new legislation preserves particular sections of that previous legislation, then the supervening legislation overrides. The court will not entertain a futile consideration of repealed provisions that have no relevance or applicability to the law as it currently stands. I agree with the submission of counsel for the first defendant that the proper role of this court is to interpret and pronounce on the effect of subsisting legislation and not to offer an opinion on the effect in law before the coming into force of any amendment. However, this court recognizes that the matter having been raised has created unnecessary uncertainty and as a result has become an issue of immense importance. To allow this uncertainty to continue would have far-reaching and unintended consequences, affecting citizens who are dual nationals, whether they live in Sierra Leone or not. It therefore forced this court to remove any uncertainty that remains, even though the plaintiff now seeks to withdraw his action. In doing so, I have relied on the various statements of case filed by the parties. Apart from naturalization, Sierra Leone citizenship can be acquired by the following ways pursuant to the 1973 Act as amended. Section 2, citizenship by birth. Every person who, having been born in Sierra Leone before the 19th day of April 1971, or who was resident in Sierra Leone on the 18th day of April 1971, and not the subject of any other state, shall on the 19th day of April 1971 be deemed to be a citizen of Sierra Leone by birth, provided that A, his father or grandfather was born in Sierra Leone, and B, he is a person of Negro African descent. Section 3. Citizenship by birth in Sierra Leone. Every person in Sierra Leone, on or after the 19th day of April 1971, in the circumstances set out in Section 2, shall be deemed to be a citizen. Section 4. Citizenship by birth outside Sierra Leone. Every person born or resident outside Sierra Leone on or before the 18th day of April 1971, and who, but for such birth or residence outside of Sierra Leone, would be a citizen of Sierra Leone by virtue of Section 2, shall on the 19th day of April 1971 be deemed to be a citizen of Sierra Leone by birth. Section 5. Citizenship by descent. Every person born outside Sierra Leone on or after the 19th day of April 1971 of a father who was or would, but for his death, have been a citizen of Sierra Leone by virtue of Sections 2, 3, and 4 is a citizen of Sierra Leone by birth. 6. Other category of citizenship. Every person whose mother is or was a citizen of Sierra Leone by virtue of Sections 2, 3, 4, and 5, and who does not or did not acquire the citizenship of another state, shall be deemed to be a citizen of Sierra Leone by birth. Counsel for the plaintiff's argument was that Section 11 of the 1973 Act is mandatory, clear, and emphatic. See Section 10 of the plaintiff's statement of case. That the words, I quote, shall cease, imposes a mandatory and or compulsory compliance with the Act and admits no discretion or contrary interpretation other than the ordinary meaning as stated and or conveyed therein. He further stated that there is no ambiguity or lacuna and that the section is plain and clear. I have considered the arguments advanced by counsel for the first defendant in his statement of case. At paragraph 87, he states as follows: it is admitted that the section did state that the consequences then of the possession of another citizenship, dual nationality, if possession of dual nationality was intended to effect a loss of citizenship of Sierra Leone, the section was glaringly silent on this. At best, it could only have operated, if at all, as a ground or reason for non-recognition of the other nationality when set against Sierra Leone nationality. For such an important matter involving loss of citizenship, it is submitted that it could not be implied by any reason and proper reading of the section. End of quote. As stated earlier, the function of this court is to interpret and give effect to the law as it currently stands. Section 10 of the Sierra Leone Citizenship Amendment Act 2006 repeals Section 11 of the 1973 Act in its entirety. As a result, Section 11 does not represent the law as it currently stands. All matters concerning citizenship are to be considered only by reference to the sections of the 1973 Act that were not repealed and the provisions of the 2006 Act. It follows that the provisions of the Section 11 of the 1973 Act are obsolete and require no interpretation or guidance from this court. For the avoidance of doubt, save for the exceptions provided for in the Constitution, there is no bar to holders of dual citizenship holding public office or exercising any of the rights afforded to any Sierra Leonean citizen, to all Sierra Leonean citizens. Those rights are clearly set out in both the 1973 Act, that is the unrepealed sections, and the Amendment Act of 2006. Therefore, in the circumstances of this case, the declaration sought is unnecessary. A consideration of Section 11 of the 1973 Act would only be necessary if, which it is not the case and is unlikely to ever be the case, the court was being invited to consider an election that had taken place prior to Section 11 being repealed. I shall now turn to Section 176(1)(a) of the Constitution. I will address this issue I will address the issue that exercised much debate in the run-up to the elections and which formed the basis of the answer sought in A1 to 4 and the declaration sought in paragraph C, D, E and F of the plaintiff's originating notice of motion. Namely, whether section 76(1)(a) of the Constitution disqualifies Sierra Leoneans who hold dual citizenship from standing for Parliament. I address this issue because, as I said in paragraph 26 above, this matter having been raised. Additionally, this action is no ordinary action. It is not an appeal that can be abandoned or an issue which raises a question of fact that can be settled. This is a fundamental constitutional issue which raises serious questions for the democracy of this country. It would therefore be a serious failing of this court if we allowed the application of the withdrawal without expressing an opinion on this important issue. The court would lay itself open to the suggestion that it had sacrificed clarity and certainty at the altar of expediency and convenience, or, as I stated earlier, allow itself to be used in this way. Further, it is in my view that the issue raised in the declaration sought by the seventh defendant, a political party, can only be addressed and dealt with decisively by consideration of section 76(1)(a). That said, section 76(1)(a) now has to be interpreted in a manner that is consistent with the will of Parliament as evinced in the 2006 Citizenship Act. Prior to 2006, it was not lawful for Sierra Leoneans to hold dual citizenship. Section 76(1)(a) therefore did no more than reflect the law as it stood then. Since 2006, it has been lawful and permissible for Sierra Leoneans to hold dual nationality. Section 173 of the Constitution foreshadowed that the law concerning citizenship might change and provided that any, and I quote, act relating to citizenship shall not be amended, repealed, reenacted, or replaced unless the bill incorporating such amendments, repeal, reenactment, or replacement is supported at the final vote thereupon by the votes of not less than 2/3 of the members of Parliament, end of quote. This is just as well, because our Constitution is unique in that, unlike so many others in Africa, it does not deal with citizenship and the qualifications for attaining such. The significance of Section 173 is that it allows Parliament's constitutional provisions. It allows Parliament to amend constitutional provisions. And when this happens, the pertinent provision, in this case 76(1)(a), is superseded by the new provision. Section 76(1)(a) is therefore subject to the relevant provisions of the Citizenship Act 2006, assuming, as we must, that 2/3 of the members of Parliament voted to enact it. This court has in the past adopted the purposive approach to statutory interpretation in interpreting other sections of our Constitution. See Charles F. Mackay versus S.E. Bearer and another, S.E. 2 of 2007, 3rd August 2007, unreported, per U.H. Tijanjalo, JSE. See also Sierra Leone Enterprises versus Attorney General and Minister of Justice, S.E. 4, 2005, 18th July 2008, unreported. In the latter case, Rhodesviver JSE relied on the Privy Council decision in AG of the Gambia versus Momodu Job, 1984, Appeal Cases 689, at page 700. There, Lord Diplock stated inter alia, I quote, "A constitution, and in particular that part of which protects and entrenches fundamental rights and freedoms to which all persons in the state are to be entitled, is to be given a generous and purposive construction," end of quote. Similarly, in the Nigerian Supreme Court case of Nafiu Rabiu versus the state, 1981, 2 NCLR 293 at page 326, Udo Udoma, JSC stated, and I quote, where the in the wider or in the narrower sense, in my view, this court should, whenever possible, and in response to the demands of justice, lean to the broader interpretation, unless there is something in the text or in the rest of the Constitution to indicate that the narrower interpretation will best carry out the object and purpose of the Constitution, end of quote. There's no reason to deviate from that approach now. Several English authorities have also adopted the same approach to statutory interpretation. In the case of Monsell and Ollins 1975, Appeal Cases 373, Lord Simons explained the approach as follows, I quote, the first task of a court of construction is to put itself in the shoes of the draftsman, to consider what knowledge he had, and importantly, what statutory objective he had. Being thus placed, the court proceeds to ascertain the meaning of the statutory language, end of quote. As previously stated, Section 761A gave effect to the Citizenship Act 1973, which self-evidently was the governing and applicable act when the Constitution was passed. However, 761A, in accordance with Section 173, Section 176(1)A, should be read as now giving effect to the Citizenship. Beg your pardon, I'll read that again. I'm sorry. However, in accordance with Section 173, Section 761A should be read as now giving effect to the Citizenship Amendment Act 2006. The Constitution is a living document, and as Lord Bingham stated in the case of R versus Secretary of State for Health, ex parte interval 2003 to Appeal Cases 687, there is, I quote, there is no inconsistency between the rule that statutory language retains the meaning it had when Parliament used it, and the rule that a statute is always speaking. If Parliament, however long ago, passed an act applicable to dogs, it could not properly be interpreted to apply to cats, but it could properly be held to apply to animals which were not regarded as dogs when the act was passed, but are so regarded now, end of quote. In the English case of the Royal College of Nursing of the United Kingdom and the Department of Health and Social Security, 1981, Appeal Cases 80 at page 822, a case which concerned the Abortion Act 1967 in that jurisdiction, and whether nurses could lawfully take part in a termination procedure not known when the act was passed. Lord Wilberforce stated, and I quote, in interpreting an act of Parliament, it is proper and indeed necessary to have regard to the state of affairs existing and known to Parliament to be existing at the time. It is a fair presumption that Parliament's policy or intention is directed to that state of affairs. Leaving aside cases of omission by inadvertence, this being no such case, when a new state of affairs or fresh set of facts being on policy comes into existence, the courts have to consider whether they fall within the parliamentary intention. They may be held to do so if they fall within the same genus of facts as those to which the express policy have been formulated. They may also be held to do so if there can be detected or clear purpose in the legislation which can be fulfilled if the extension is made. How liberally these principles may be applied must depend upon the nature of the enactment and the strictness or otherwise of the words in which it has been expressed. The court should be less willing to extend express meanings if it is clear that the act in question was designed to be restrictive or circumscribed in its operations rather than liberal or permissive. They will be much less willing to do so where the subject matter is different in kind or dimension from which the legislation was passed. In any event, there is one course which the courts cannot take. Under the law of this country, they cannot fill gaps. They cannot, by asking the question, current case not being one in contemplation, if the facts had been before it, attempts themselves to apply the answer, if the answer is not to be found in the terms of the Act itself." End of quote. Another illustration of interpretation of a statute to reflect current circumstances is the extension of the term bodily harm in the Offences Against the Person Act 1861 to mean psychiatric harm, a concept which was unknown at the time of passing the legislation. See R versus Chan Fook, 1991, 1 Weekly Law Report 687, and R versus Buster Subnum, R versus Ireland, 1998, Appeal Cases 147. Conclusion. If, as stated above, the Constitution is a living document, then it must adapt and respond to changes in society's attitudes. From time to time, Parliament steps in. For example, the Devolution of Estates Act 2007 and its effect on Section 27(4)(d) of the Constitution, insofar as marriage, devolution of estate on death, and other interests of personal law are concerned. And more recently, the past Abolition of Death Penalty Act 2021 for certain offences, murder, treason, robbery with aggravation, and its effect on Section 16(1) of the Constitution. The same can be said for the 2006 Act. It could not surely have been the intent of Parliament to give to some of its citizens a right whilst living in place positions which deprived them of the benefits of that same right. On the occasions where Parliament does not act, this court must step in to ensure that the Constitution or any enactment is interpreted to reflect society's evolution and progressive attitudes, particularly towards gender, tribe, religion, race, or citizenship, so that no one group or part of a group is left out of an inclusive society. In doing so, this court must be careful to ensure that it is not making any new law, but merely interpreting that which already exists in a manner consistent with the will of Parliament. It follows that the changes made by the 2006 Act are in accordance with the Constitution. The 2006 Act does not restrict the rights of any category of citizens and self-evidently does not discriminate against any citizen who holds dual nationality. Section 76 of the Constitution must be considered in the light of Section 173, which gave Parliament the discretion to legislate in respect of matters concerning citizenship. Parliament, in its wisdom, has decided that it should not be unlawful for Sierra Leoneans to hold another nationality. The mischief against which Section 76(1)(a) was aimed is no longer in existence. Indeed, what was once unlawful is now lawful. It follows, a fortiori, that there is no automatic disqualification by virtue only of holding dual or multiple citizenship. The effect of this is that the disqualification of Sierra Leonean citizens who voluntarily hold citizenship of another country by virtue of Section 76(1)(a) is now only relevant to elections conducted before the 2006 Act was passed. If it needs stating, the law as it now stands is that Sierra Leonean citizens who are voluntarily citizens of another country are no longer disqualified from standing for Parliament. The only citizens with dual nationality excluded under Section 76(1)(a) are naturalized citizens, given that only citizens other than naturalized citizens are qualified under Section 75.
Gentlemen, go on.
I'll have to go over that again, please. The only citizens with dual nationality excluded under Section 76(1)(a) are naturalized citizens, given that only citizens other than naturalized citizens are qualified under Section 75 of the Constitution. Until such time as Parliament amends the law, this disqualification remains in force. Thank you.
I have the honor of reading the decisions of Ralph Mark JSC, Leonard Thompson JSC, and Robert JSC. This case primarily deals with the question of who is a citizen of Sierra Leone under the Constitution of Sierra Leone for the purpose of contesting presidential and parliamentary elections. And at what point in time that person loses his citizenship, and whether having lost, he could regain it at a later date, and the procedure to be followed. Section 1271 and 2 of the 1991 Constitution deals with the jurisdiction of the Supreme Court. It gives the Supreme Court original jurisdiction to interpret a statute. It provides thus, I quote, "A person who alleges that an enactment or anything contained in or any other enactment is inconsistent with or is in contravention of a provision of this Constitution may at any time bring an action in the Supreme Court for a declaration to that effect," end of quote. Section 1272 states, I quote, "The Supreme Court shall, for the purpose of a declaration under that section 1, make such orders and give such directions as it may consider appropriate for giving effect to or enabling effect to be given to the declaration so made," end of quote. During the course of the proceedings, the plaintiff discontinued the entire action against the defendants. This was clearly an unacceptable conduct. Democracy and good governance demands that those conducts which undermine democracy and good governance ought not to be encouraged. The plaintiff's conduct was nothing but a recipe for chaos. The first defendant was removed from the ballot box days to the general election, and not too long the plaintiff after the conduct was filed a notice of discontinuance. It is clearly an abuse of process. The plaintiff, David FORNA, on the 5th of February 2018, filed in the registry originating notice of motion, posing certain questions, calling on this court to answer, and if they were answered in a certain manner, several declarations were also sought in the same motion paper. The plaintiff asked this court firstly to interpret sections 41, 75, and 76 of the 1991 Constitution of Sierra Leone, and the effect of interpretation of these provisions will help determine the following. One, whether a naturalized citizen of Sierra Leone is disqualified from being elected as a member of parliament, and thereby also disqualified to be elected president. Two, whether a citizen of a country other than Sierra Leone, having become one voluntarily or is under a declaration of allegiance to such a country, is disqualified from being elected as a member of parliament. If the answer to questions 1 is in the affirmative, what is the effect in law of a naturalized citizen running for election as a member of parliament and consequently for the office of president? If the answer to question 2 is in the affirmative, what is the effect of such a citizen running for parliament and consequently and also for the office of president? The plaintiff has also posed for determination the interpretation of sections 5 and 7 of the Sierra Leone Citizenship Act 1973 as amended by Act number 11 of 2006. A, whether upon a proper construction of section 10 of the 1973 Act as amended and before coming into force of the Amendment Act, a person having Sierra Leone citizenship and any other citizenship at one and the same time by operation of law cease to be a Sierra Leonean. B, whether upon interpretation of section 11 of the 1973 Citizenship Act as amended before the coming into effect of the 2000 Amendment Act, a person upon attaining the age of 22 years being a citizen of Sierra Leone and also a citizen of another country by operation of law cease to be a citizen of Sierra Leone. If the answer to question 1 is in the affirmative, can such a person be eligible to contest parliamentary and presidential election? The plaintiff sought the following declarations. 1, that by virtue of section 41, 75, and 76 of our Constitution of Sierra Leone, no person shall be qualified to be elected as a member of parliament or president if he is a naturalized person. 2, by virtue of section 41, 75, and 76 of our Constitution, no person shall be qualified to be elected as a member of parliament or president if he is a citizen of a country other than Sierra Leone, having become such a citizen voluntarily or is under a declaration of allegiance to the other country. By virtue of section 10 and 11 of the 1973 Act, a citizen of Sierra Leone who was also a citizen of another country ceased to be a Sierra Leonean. The first defendant on the 1st of March 2018 filed a statement of case. In summary, it contained several averments, and in particular he avers he is a citizen by birth and descent. He further averred that he acquired in 1975 a U.S. citizenship but renounced it in November 2017, long before the 2018 elections. He supported this by filing an affidavit on the 19th of March 2018 verifying same. He attached to his affidavit documents such as his birth certificate, his current Sierra Leone passport, his certificate of loss of American nationality, together with his oath and affirmation of renunciation of American nationality and nomination certificates for parliamentary and presidential elections. There is no statement of case by the second defendant. The third and fourth defendants filed a joint statement of case. The seventh also filed a statement of case. This court on the 1st of March 2018 ordered the statement of case to be filed in respect of the 5th, 6th, and 7th defendants. The declaration sought by the 7 defendants refer to not only the provisions of the laws, the citizen laws, but also the interpretation of section 75(1)(a) of the 1991 Constitution, section 76(1)(a) of the 1991 Constitution. The 7 defendants' argument is that a naturalized citizen cannot contest for membership of parliament. His submission is grounded on constitutional provisions, section 76(1) of the 1991 Constitution, which provides thus, I quote, "No person shall be qualified for election as a member of parliament, A, if he is a naturalized citizen of Sierra Leone or a citizen of a country other than Sierra Leone, having become such a citizen voluntarily or is under a declaration of allegiance to such a country." Upon the plain and literal reading of the said provision of the Constitution, it is arguably the case that no person shall be qualified for election as a member of parliament where is a naturalized citizen of Sierra Leone or a citizen of a country other than Sierra Leone, such citizenship having been obtained voluntarily or the individual in question is under a declaration of allegiance to such a country. It is safe to conclude that at the time the 1991 Constitution was enacted, the concept of dual nationality was not part of the laws of Sierra Leone. The 1973 Citizenship Act. Under the 73 Citizenship Act, Section 2 provides every person who having been born in Sierra Leone before the 19th day of April 1971 and not the subject of any other state shall on the 19th day of April 1971 be deemed to be a citizen of Sierra Leone by birth, provided A, his father or his grandfather was born in Sierra Leone, B, is a person of Negro African descent, that any person of Sierra Leonean parentage who carries a foreign citizenship and is past the age of majority was automatically deemed to have lost their Sierra Leonean citizenship, in quote. The effect of the 73 legislation was twofold. Firstly, it provided the manner in which citizenship was acquired, and it also made provision for the manner in which citizenship was automatically lost in a situation where a person who had acquired citizenship by virtue of Section 2 loses that citizenship where he is a subject of another state and or carries a foreign citizenship after the age of 21. Whereas such citizenship is lost in a manner provided for under the Act, the plain intention of Parliament was that a non-citizen cannot qualify for membership of Sierra Leone Parliament. The Sierra Leone Citizenship Amendment Act 2006. This was an act of Parliament that was enacted to amend the Sierra Leone Citizenship Act of 1973. The effect of the amendment of this act is that citizenship is no longer lost or deemed to be automatically lost by acquisition or possession of citizenship of another state. The provisions of Section 75 are subject to the provisions of Section 76 only in respect to limited category of citizenship acquired otherwise than by birth. The rules of statutory interpretation require words to be given their natural or ordinary meaning without putting a gloss on it. Upon its true construction by way of the literal rule, a citizen of Sierra Leone, as provided for Section 75, for the purposes of Section 75, notwithstanding that he is a citizen of a country of another, notwithstanding that he is a citizen of a country other than Sierra Leone, having become such a citizen voluntarily or is under a declaration of allegiance to such a country. A citizen of Sierra Leone who acquired citizenship by registration and naturalization is unarguably excluded by the provisions of Section 75 and 76 from being eligible to contest for membership of Parliament. The purposive approach to statutory interpretation. Lord Simon explained the purposive approach in Monsell and Hollins 1975 appeal cases 373 in these words, I quote, "The first task of a court of construction is to put itself in the shoes of the draftsman, to consider what knowledge he had and importantly what statutory objective he had." End of quote. Being thus placed, the court proceeds to ascertain the meaning of a statutory language. This is sometimes referred to as the approach to statutory interpretation. In Leader and Duffy, 13 appeal cases 294, Lord Horsbury, Lord Chancellor at page 301 remarked, I quote, "But I agree, you must look at the meaning of the instrument taken as a whole in order to give it effect, if it be possible to do so, to the intention of the framers of it." Lord Justice in English Court of Appeal in Oliver Ashworth Holdings Limited and Ballard Kent Limited, 1999, to All England Law Reports at page 799 had this to say: "It is nowadays misleading, and perhaps it always was, to seek to draw a rigid distinction between literal and purposive approaches to the interpretation of acts of Parliament. The difference between the purposive and literal construction is in truth one of degree only. The real distinction lies in the balance to be struck. In the popular case between the real meaning of the words on the one hand and the context and purpose of the measure in which they appear on the other." End of quote. The first defendant has deposed in his affidavit that he carries a Sierra Leone passport and had keen interest in the socio-economic and political processes of his native land. The plaintiff has failed to provide any evidence to the contrary. In my view, the plaintiff was aware of the status of the first defendant prior to March 2018. Section 41 of the 1990 Constitution deals with the eligibility of a candidate for presidential election. One of the criteria is that he should be qualified to be elected as a member of parliament. This criteria is connected with section 75 and section 76(1) of the 1991 Constitution. He clearly met the criteria. The first defendant is a Sierra Leonean by birth and not a naturalized citizen. He renounced his American citizenship long before nomination. The plaintiff again was aware of these facts. I reiterate, in the result, the plaintiff's claim fails. The declaration sought by the 7 defendants is hereby granted. I declare and order that any person who, upon attainment of 21 years, was or is a citizen of Sierra Leone and also a citizen of any other country, did and does not by operation of law or any other means is to be a Sierra Leonean, the plaintiff shall bear the cost of the action up to the date it was discontinued in favor of the first, third, and fourth defendants.
I'm sorry, my gentlemen, 5 minutes. Just for 5 minutes, please.
justice and one more.
My name is Patrick Salia from Freetown, where we cover the impossible or untold stories.
At SLBC, we believe that every story from any ethnic boundary is important to us because we seek the news with all our zeal and our might.
We go anywhere to uncover and analyze the impossible.
From the Diamond Ridge district of Kono in Koidu, Semel City, my name is Dauda Kamara.
This is Switchboard, second capital of Sierra Leone, popular for its quality Gary production. And the leader in cleanliness. In Amende local dialect, when we say bolo, it means this is yours. My name is Abdul Fattah Bunubai Kamara.
This is the Rokel River, which is not only useful for many domestic purposes for communities around here, but also runs through the Bumbuna hydroelectric dam that provides electricity.
This is Savage Pits, situated in Tomburu Town, Kamara Chiefdom, where the heirs of dozens of people that were killed in the decade civil conflict in this part of the country were dumped.
My name is Joshua Sapichikon.
From the heart of the capital of Bombali district, which is popularly known for its Gara tie dyeing, I'm Hassan Fore Kamara in Makeni City, and this is SLBC.
SLBC is the true voice of Sierra Leone because we are the Sierra Leone Broadcasting Corporation.
My name is Abdul Karim Kano in Magoroka, headquarter town for the iron ore-rich districts of Tonkolili.
This is SLBC.
This is the SLBC.
This is the SLBC.
This is the SLBC.
And this is SLBC.
And this is the SLBC.
So let we try. You all don't live now we can. Now we go try for let we go before. Salon don't live now we. Salon for
well now we are. I say salon man and woman as a me. Yes, Hindu we sweet salon for well now we are. Where we get we gold, where we get we diamond, where we get we iron or white for where we where we get we rutile, where we get we bauxite. Fish in our water plenty, white for where we I say salon man and woman and some people. Let's do we sweet salon for well now we are. I say salon man and woman and some people. Let's do we sweet salon for well now we are. If petrol day, lights day na the whole country, motor car they won't open no white for well but we. If parents get good pay, the king go school. If teacher get good pay, all the king then go land. I say salon man and woman as a big. Waiting do we sweet salon for well now we are. I say salon man and woman as a big. Waiting do we sweet salon for well now we are. Waiting do we sweet salon for well. Waiting do we sweet salon for well.
You're watching the SLBC on Channel 31, the authentic voice of Sierra Leone.
Memorize this. I wish you them Sunday. They must be free. Great is the love we should have for thee. Family we should be united whenever we stand.
A place cannot produce poems. It can only not prevent them. And Freetown is good at that, for Freetown has its own sudden elegances.
My lords, I have had the privilege of reading the judgment of my learned brother, Honorable Mr. Justice N.C. Brownmark, JSC. I will adopt his summary of the facts in this case. I also agree with his orders as to cost. Having said this, I shall now proceed to opine on the law as it is. I shall start by expressing my views on an important question on which Justices Brownmark and Thompson hold different but well-researched and refreshing views. The question relates to whether there is an apparent conflict between Section 126 of the Constitution of Sierra Leone 1991, Act number 6 of 1991, and Section 47, Subsection 3 of the Public Elections Act 2012. In order to determine the question of whether a conflict exists or not, I shall, first of all, set out the said provisions in extensio. Section 126 of the Constitution provides as follows, quote, a single justice of the Supreme Court acting in its criminal jurisdiction and 3 justices of the Supreme Court acting in its civil jurisdiction may exercise any power vested in the Supreme Court not involving a decision in a cause or matter before the Supreme Court, save that A, in criminal matters, if any such justices refuses or grants an application in the exercise of any such power, any person affected thereby shall be entitled to have the application determined by the Supreme Court constituted by 3 justices thereof. And B, in civil matters, any order, direction, or decision made or given in pursuance of the powers conferred by this section may be varied, discharged, or reversed by the Supreme Court constituted by 5 justices thereof. The side notes to this provision clearly states that it relates to the powers of the Supreme Court in interlocutory matters. Subsection 3 of Section 47 of the Public Elections Act 2012 provides as follows, quote, an objection against the nomination of a presidential candidate shall be heard by the Supreme Court made up of 3 justices whose decision shall be given within 30 days of the lodging of the objection, unquote. A proper construction of the 2 provisions will reveal that there is no conflict. The objection to a candidate to participate in a presidential elections, to my mind, could be equated to an interlocutory process. After the nomination, there will still be the presidential elections, which is the end process. It is only when there is a challenge to the results of a presidential elections that the Supreme Court shall be called upon to determine its validity. Section 55 of the Public Elections Act 2012, number 4 of 2012, is clear on this point. It provides as follows, quote, a person who is a citizen of Sierra Leone and has lawfully voted in a presidential election may challenge the validity of that election by petition to the Supreme Court within 7 days after the declaration of the results of a presidential election under subsection 2 of section 52, unquote. It should be noted here that no reference is made to the number of Supreme Court judges, which will invariably lead to the conclusion that it must be the full panel of the court. Subsection 3 of section 47 does clearly state that the decision of the panel of 3 is subject to an appeal to a panel of 5, as provided for in section 126 of the Constitution. Had Parliament intended that decision to be final, it will have said so. I say this because in section 145 subsection 1 of the said Act, which deals with parliamentary elections petitions, it is explicitly provided that, quote, an appeal shall lie to the Court of Appeal from the determination of the High Court upon an election petition, and the decision of the Court of Appeal shall be final to all intents and purposes, unquote. There is no such specificity in subsection 3 of section 47. Reading subsection 3 of 47 of Act number 4 of 2012, subsection 4 of section 43 of same, and section 126 of the Constitution together, it is my opinion that any disqualification of any candidate under the former shall be subject to an appeal to the full panel of the Supreme Court. It is important to take into consideration that subsection 4 of section 47 only refers to the Supreme Court without mentioning the required quorum. Based on my opinion profiled in the following paragraphs, I hold that subsection 3 of section 47 of the Public Elections Act 2012 does not contravene Section 126 of the Constitution of Sierra Leone 1991, number 6 of 1991, but rather complements it. In any event, even if it does contradict it, the constitutional provision will take precedence. Now let me go to the issue in this case. The plaintiff in this matter unconditionally withdrew his action against all the defendants before the hearing. This means that all the relief sought against the defendants ceased to exist, and so this court lacks jurisdiction to determine them in the manner in which they were raised. However, the application for this continuance was made after all the parties here have filed their respective statements of case. This gives this court a treasure trove of legal submissions and authorities to assist it in answering the questions asked. After arguments regarding the withdrawal, counsel for the 7th defendant, Yasmin Kisu Sheriff, asked this court to determine the declaration prayed for in paragraph H of the originating notice of motion of the plaintiff dated the 5th day of February 2008, to wit, quote, that by virtue of section 11 of the Sierra Leone Citizenship Act number 4 of 1973 as amended, and before the coming into effect of the Sierra Leone Citizenship Amendment Act number 11 of 2006, any person who upon attaining the age of 22 years, being a citizen of Sierra Leone and also a citizen of another country, by operation of law ceased to be a citizen of Sierra Leone, unquote. In our view, which I uphold, the said prayer is of such constitutional and public interest significance that it should be clarified by the Supreme Court. In the statement of the plaintiff's case, counsel for the plaintiff at paragraph 3A refers to section 10 of the Sierra Leone Citizenship Act number 4 of 1973 as amended, and the Sierra Leone Citizenship Amendment Act number 11 of 2006. For ease of reference, I shall reproduce these provisions. Section 11 of the Sierra Leone Citizenship Act 1973 provides as follows, quote, any person who, upon attaining the age of 21 years, is a citizen of Sierra Leone, who upon attaining the age of 21 years is a citizen of Sierra Leone and a citizen of another country, shall cease to be a citizen of Sierra Leone upon attaining the age of 21 years, or in the case of a person of unsound mind, at such later date as may be prescribed, unless he has complied with paragraphs A, B, C of section 9. Section 10 of the Sierra Leone Citizenship Act 1973 provides as follows, quote, no person shall have Sierra Leone citizenship and any other citizenship at one and the same time, unquote. Sierra Leone Citizenship Act number 13 of 1976, section 9 deals with conditions precedent to the grant of certificate of citizenship by naturalization. In this submission, Mr. Santos Macaulay, counsel for the plaintiff, argues that sections 10 and 11 of the 1973 Act as amended are mandatory, clear, and emphatic terms, more specifically with the use of the term shall in section 10, and the words that on taking the citizenship shall cease in section 11. He also submits that there is no lacuna concerning sections 10 and 11 of the 1973 Act. In consequence, dual citizenship was barred, so much so that on taking the citizenship of any other country at one and the same time as that of Sierra Leone citizenship, he shall cease forthwith by operation of law without doing anything more from being a citizen of Sierra Leone. Mr. Macaulay further submits that pursuant to section 10 and 11 of the Sierra Leone Citizenship Act number 4 of 1973 and before 26 October 2006, the first defendant ceased to be a citizen of Sierra Leone and in consequence thereof lost his citizenship of Sierra Leone. Immediately he became a citizen of the United States of America and took the oath of allegiance to the United States. Mr. Macaulay submits that the Sierra Leone Citizenship Amendment Act number 13 of 1976 is significant as regards the first defendant, as it deals, amongst others, with steps to be taken, including the oath of allegiance to the state of Sierra Leone on reacquiring citizenship. He argues that notwithstanding provisions of Section 4 of the Sierra Leone Citizenship Amendment Act number 11 of 2006, which side notes read, repeal and replacement of Section 9 of Act number 4 of 1973, that is the principal legislation, sought to purportedly repeal and replace Section 9 of the principal legislation, which ceased to be the law by virtue of the Sierra Leone Citizenship Act number 13 of 1976, rather than Section 9 of Act number 13 of 1976. Mr. Macaulay further argues that by statutory instrument number 3 of 2007, whose short title reads thus, quote, the Sierra Leone Citizenship Act 2006, date of commencement, order 2007, and the exercise of the powers conferred on him, the Minister of Internal Affairs ordered that the Sierra Leone Citizenship Amendment Act 2006 shall deem to come into operation on the 26th day of October 2006. According to him, that provision is not retrospective. He argues further that the Sierra Leone Citizenship Amendment Act number 11 of 2006 has not in any way repealed sections 41, 75, and 76 of the Constitution of Sierra Leone 1991. On the contrary, the qualifications specified in sections 41, 75, and 76 still remain the eligibility criteria to be met by any person seeking to be elected a member of parliament or president of Sierra Leone, notwithstanding that dual citizenship is now allowed under the said Act number 11 of 2006. He submits that there is no conflict between the two enactments, as the provisions of the Constitution will always be the supreme law. In support of this proposition, he cited the dictum of Charles Hayfrom Benjamin, JSC, in the Ghanaian case of New Patriotic Party against the Inspector General of Police, 2001, or Ghana Law Report, Ghana Supreme Court, 1993, in the following words, quote, where any law or action is in conflict with the letter and spirit of the Constitution, which is the fundamental law of the land, then to the extent of such conflict or inconsistency, that law is unconstitutional, void, and unenforceable, unquote. Mr. Macaulay proffers that the Citizenship Amendment Act number 11 of 2006 did not automatically reconfer citizenship with the insertion of the new section 19A on all those who had lost him by operation of law by virtue of sections 10 and 11 of Act number 4 of 1973, and before the coming into effect of Act number 11 of 2006, or had ceased to be citizens of Sierra Leone by any other manner as provided for under the 1973 Act. Counsel for the first defendant, Dr. Abdullahi Conte, in his statement of case, paragraph C, under the rubric arguments of submissions, submits that the plaintiff, by the originating notice of motion, is seeking to abuse the jurisdiction of the court in the guise of a constitutional challenge. Dr. Conte proffers that the appropriate way to approach this court in the circumstances of a case where a person seeks to object to the candidacy of a candidate for presidential election is expressly provided for by Section 47 of the Public Elections Act 2012. This should be done by way of a properly formulated objection, if any, to the candidacy of that candidate. Dr. Conte urges this court to decline the invitation to interpret certain provisions of the Citizenship Act, in particular sections 10 and 11 of Act number 4 of 1973. He argues that the plaintiff expressly requests the court to state the effect in law before they come into effect of Act number 10, Act number 11 of 2006. Such an invitation is manifestly an invitation to entertain an academic question. He submits that the relevant legal and subsisting provisions on dual nationality are clearly stated in Section 5 of Act number 11 of 2006. He admits that dual citizenship by Sierra Leoneans is now permissible. Dr. KANDEH argues that it is not the proper role of any court to pronounce on the effect of the law before coming to effect of an amending legislation. The proper role of a court, when properly seized, is to interpret and pronounce on the effect of subsisting legislation. The declaration sought. This court has been asked to make a declaration that by virtue of Section 11 of the Sierra Leone Citizenship Act number 4 of 1973 as amended, and before the coming to effect of the Sierra Leone Citizenship Amendment Act number 11 of 2006, any person upon attaining the age of 22 years, being a citizen of Sierra Leone and also a citizen of another country, ceases to be a citizen of Sierra Leone. The plaintiff went further to seek a declaration that in the light of the declarations C to H being granted, that the first defendant is disqualified for election as a member of Parliament of the Republic of Sierra Leone and thereby disqualified from election as President of Sierra Leone. I will comment that the declaration sought in paragraph 4 of the plaintiff's statement of claim is purely academic and inconsistent with the interpretative powers of the Supreme Court. The Supreme Court is required to interpret an existing law and not the effect of a repeat provision in the statute. The plaintiff is asking us to determine the citizenship status of the first defendant between the enactment of the Citizenship Act 1973 as amended and the coming into effect of Act number 11 of 2006. It is my view that this court should not and must not do so. It is a principle in constitutional interpretation that a statute after being repealed becomes ineffective. The repealing statute abolishes a repealed statute as if it has never been made by Parliament, except for saving clauses. Each and every part of the statute is considered unconstitutional. Thus, the repeal of an act of Parliament caused it to cease to be part of the corpus juris, or the body of law. As Benyon puts it in Benyon on Statutory Interpretation, 5th edition, section 85, pages 300 to 301, quote, the judicial effect of repeal and expiry are identical. In each case, the floodlight is switched off, unquote. This view has judicial support in the persuasive English case of Surretis against Edison, 1829, 9B and C, 752, where Lord 1013 said, quote, where an act of Parliament is repealed, it must be considered, except as to transactions passed and closed, as if it had never existed. Tyndall CJ states the exception more widely in K against Gobbin, when he said, quote, the effect of repealing a statute is to obliterate it as completely from the records of Parliament as if it had never been passed, and it must be considered as a law that never existed except for the purpose of those actions that were commenced, prosecuted and concluded whilst it was an existing law. Let me just get a taste of water. In the instant case, section 10 of Act number 4 of 1973 was expressly repealed and replaced by section 5 of Act number 11 of 2006. It follows that the said provision should be treated after the operative date of repeal as if it was never enacted. I would therefore reject the argument of counsel for the plaintiff that pursuant to sections 10 and 11 of the Citizenship Act number 4 of 1973 and before the 26th day of October 2006, the first defendant ceased to be a citizen of Sierra Leone. Immediately he became a citizen of the United States and took an oath of allegiance to the said United States. On the contrary, I hold that as soon as Act number 11 of 2006 was enacted, the pre-sections of the Act number 4, 1973, ceased to have any legal effect. The first defendant as a citizen by birth, as opposed to a citizen by naturalization, was automatically entitled to the benefit of the amendment, save the limitations set out in sections 41, 75, and 76 of the Constitution of Sierra Leone, number 6 of 1991. The fundamental issue. The fundamental issue here is whether a person holding dual citizenship is qualified to be a member of parliament and thus be elected as president of the Republic of Sierra Leone. The issue of citizenship is not expressly provided for in the Constitution of Sierra Leone. The main reference to citizenship is to be found in section 173, which provides that, quote, the provisions of any consequential provisions act under this constitution and any act related to citizenship shall not be amended, repealed, reenacted, or replaced unless the bill incorporating such amendments, repeal, reenactment, or replacement is supported as a final vote thereupon by the votes of not less than 2/3 of the members of parliament. There's no evidence that the 2000 Act did not receive the necessary 2/3 votes of members of parliament, and so the maxim omnia presumitor rite est solumita esse acta donect in contrarium applies. This means that all things are presumed to be rightly and duly performed unless the contrary is proved. The Sierra Leone Citizenship Act number 11 of 2006 flows from section 173 of the Constitution of Sierra Leone as the Sierra Leone Citizenship Act 1973 as amended, which continues to be valid law by virtue of sections 176 and 177 of the Constitution of Sierra Leone dealing with existing law and application of existing law. It follows that the law related to citizenship in Sierra Leone is governed by the Citizenship Act 1973 as amended, the Citizenship Amendment Act 1976 and 1977, and the Sierra Leone Citizenship Act 2006. The 2006 Act repealed and replaced key provisions in the 1973 Act, but did not repeal and replace any reference made to the 1976 Act. This is understandable as that Act relates only to citizenship by naturalization. In determining the key issue raised herein, the relevant provision is section 5 of the Sierra Leone Citizenship Amendment Act 2006, which provides as follows, quote, section 10 of the Principal Act is repealed and replaced by the following section. 10. A citizen of Sierra Leone may hold a citizenship of another country in addition to his citizenship of Sierra Leone, unquote. This provision needs no interpretation. The words are clear and unambiguous and must be applied according to its terms. As the authors of Hosbury's Laws of England, Statutes, Volume 44, 1, reissue, paragraph 1487, put it, quote, if there is nothing to modify, alter, or qualify the language which a statute contains, the words and sentences must be construed in their ordinary and natural meaning, unquote. Section 5 of Act number 11 of 2006 has a straightforward and clear meaning with no contradictions. It means that contrary to section 10 of the Citizenship Act 1973, which provides that no person shall have a Sierra Leonean citizenship and any other citizenship at one at the same time, a Sierra Leonean is not allowed to hold dual citizenship. Consistent with this construction, I hold that a person having Sierra Leonean citizenship may now hold the citizenship of any other country. If that person is a citizen by birth, he or she, for political correctness, shall enjoy all the rights of a citizen without dual nationality, save in specified cases provided for in the Constitution of Sierra Leone, Act number 6 of 1991. The next question, which has attracted a lot of public interest and at times hostile debates, is whether a person holding dual citizenship by virtue of section 5 of Act number 11 of 2006 is qualified to be elected as a member of parliament or president of Sierra Leone. At the answer of this question are section 75A, section 76(1)A, and section 41 of the Constitution of Sierra Leone 1991, which provides as follows. Section 75A. Subject to the provisions of Section 76, any person who is a citizen of Sierra Leone, otherwise by naturalization, shall be qualified for election as a member of parliament. 76A. No person shall be qualified for election as a member of parliament, A, if he is a naturalized citizen or is a citizen of any of a country other than Sierra Leone, having become such a citizen voluntarily or order a declaration of allegiance to such a country. Provides that no person shall be qualified for election as president unless A, he is a citizen of Sierra Leone, he is a member of a political party, has attained the age of 40 years, is rather qualified to be a member of parliament. It is noteworthy that these provisions are clear. They do not require the mobilization of any of the other canons of constitutional interpretation to determine their meanings. Before giving any interpretative answer to the questions envisaged or asked, I shall reproduce the submissions of counsel on it. I must state that both are agreed on the significant constitutional relevance of sections 41, 75, and 76 of the Constitution of Sierra Leone in determining the eligibility criteria for contestants to become a member of parliament and president. These provisions are connected to the extent that in order to be elected as president, a person must, amongst others, be qualified to be a member of parliament. In the qualifications to be a member of parliament, you must not hold dual citizenship. Counsel for the plaintiff, Senator Macaulay, made the following submission on this issue. Quote, we submit that there is no gainsaying this act, Sierra Leone Citizenship Amendment Act number 11 of 2006 has in no way, manner, or form amended sections 41, 75, and 76 of the Constitution of Sierra Leone. On the contrary, the qualifications specified in 41, 75, and 76 still remain qualifications to be met by any person seeking to be elected to be a member of parliament and or president of the Republic of Sierra Leone, notwithstanding that dual citizenship is not allowed under Act number 11 of 2006. In other words, although dual citizenship is not allowed by virtue of Act number 11 of 2006, the qualification for seeking to be elected as a member of parliament and president are not to be found in the said act, but rather expressly provided for in section 41, 75, and 76 of the said constitution. And the said qualifications remain the same. Counsel for the first defendant, Dr. Abdullahi Conte, had this to say. Quote, it is readily conceded for the first defendant that even with the possession of dual citizenship by Sierra Leoneans since 2006, the constitutional inhibitions on the eligibility of those dual citizens for the purposes of election to parliament and the presidency still remain in place. Therefore, there is no conflict between the Sierra Leone Citizenship Act 2006, allowing Sierra Leoneans to hold dual citizenship, and the relevant provisions of the Constitution limiting eligibility for the purposes of election to parliament and the presidency to only Sierra Leoneans who do not hold or possess dual citizenship. Dr. Conte submits further, quote, the temporal focus of the ineligibility criteria stated in the Constitution in sections 41, 75, and 76 is on the present and continuing holder of dual citizenship. It could be discerned from the submissions of both counsel that irrespective of the provisions of the Sierra Leone Citizenship Amendment Act number 11 of 2006, the criteria for members of parliament and president are to be found in sections 41, 75, and 76 of the Constitution of Sierra Leone. In other words, the 2006 Act did not in any way supplant the said constitutional provisions. If that were the intention of parliament, any such provision would have been unconstitutional. The concept of citizenship is deeply rooted in the principle of allegiance. It could be traced to biblical verses, particularly Matthew 6, verse 23, where it is stated that, quote, no man can serve two masters, for either he will hate the one and love the other, or else he will be loyal to the one and despise the other. You cannot serve God and mammon. Unquote. As counsel for the first defendant explains, quote, in a representative democracy, it is readily submitted on behalf of the first defendant that it is important that holders of the highest offices in the country should not possess or have dual or split allegiance stemming from the possession of dual citizenship. The requirement extends to public offices such as the highest office in the land, the presidency, legislators, parliament, and ministers of government. There should be only one locus of allegiance when it comes to these offices. It is inimical and greatly detrimental to the public interest for any country to have its elected public officials or those holding senior government positions to have dual citizenship, for the reason that they may, at such critical stage of discharging their functions, be susceptible to the temptations of split loyalty that may be involved in holding dual citizenship. Unquote. I agree entirely with Dr. Conte on this point, and will illustrate this by a scenario in which a president of Sierra Leone, I mean a president, not the president, by which a president of Sierra Leone, who is the commander-in-chief of the armed forces, is a Mabat, and simultaneously holds citizenship of another country. In the event of an armed conflict between Sierra Leone and that other country, where will his loyalty lie? If he declares war or sustains a war against the other country, it will amount to breach of allegiance to that state with all its legal implications. Conversely, if he gives any support to that country, he will be in breach of allegiance to Sierra Leone. For the reasons given herein, I hold that irrespective of the Sierra Leone Citizenship Amendment Act number 11 of 2006, Section 41, 75, 76 are the constitutional provisions containing eligibility criteria for members of parliament and the president of the Republic of Sierra Leone. That is the law as it is. Copying from John Austin, we shouldn't be thinking of the law as it ought to be. For the avoidance of doubt, in order to qualify to contest for the office of president or member of parliament, you must, amongst others, be a citizen by birth and must not hold the citizenship of any other country. Having so heard, I will clarify that this constitutional limitation could be cured by invoking Section 7 of the Sierra Leone Citizenship Amendment Act number 11 of 2006, which provides as follows. The Principal Act is amended by insertion immediately after Section 19 of the following new section, 19A. When a citizen of Sierra Leone, being of full age and capacity, has at any time acquired the citizenship of any foreign country, 1, by birth, or 2, any voluntary or formal act, or B, done any act or thing, the sole or primary purpose of which, or the effect of which was or is to acquire the citizenship of a foreign country, and that person ceased to be a Sierra Leonean by reason thereof, he may, if he so wishes, resume his Sierra Leonean citizenship. On a true construction of this section, as long as a person renounces his citizenship of the other country before submitting himself as a candidate for parliamentary or presidential elections, he shall be qualified to do so. In other words, as soon as a person is no longer under allegiance to any other country and is a citizen by birth, not by naturalization or registration, and fulfills all the other requirements laid out in sections 41, 75, and 76 of the Constitution, he shall be qualified to be elected a member of parliament and thereby eligible for election as president of Sierra Leone. My lord, this is my rule. Yes, I may. Finally, my lord, while I agree with the declaration sought, I will add, for the avoidance of doubt, where a Sierra Leonean citizen by birth who later becomes a citizen of another country later renounces that citizenship, he automatically resumes his Sierra Leonean citizenship.
Thank you. Yeah. My lord, my lady, I think we call that paragraph 49 and 50. Sorry, yes, paragraph 49 and 50 are missing from my script, I'll supply them. Actually, they deal with what Justice Jallo said in the Dabo case and the beginning of my commentary on the Australian case. I think I mistakenly left paragraphs 50 and 51 out. Gentlemen and ladies at the bar, we are going to do the corrections. The printed judgments will be available on Monday. So you can send your clerks to the High Court Registry. It'll say latest by 11. Supreme Court Registry, I beg your pardon, Supreme Court Registry. Latest by 11 a.m. The printed judgments, after the corrections have been made, will be available. But it has been broadcast live, so it's easy to, most of you know what the conclusions are, or all of you should know what the conclusions are. Thank you very much for your cooperation.
I believe so. The proceedings of the judgment, we, of course, between one of the serious case in terms of citizenship in the country Sierra Leone. I remember during the 2018 elections, Dr. KANDEH YUMKELLA, the presidential candidate for NGC, and they be able for represent in party, but one member will contest against them. Say, well, and not be denounced in citizenship where it will run for the office as a president and parliamentarian. So that the decision, the Supreme Court will look into the matter and then not take it. But I got one very important personality with me, where of course is definitely a presidential applicant. You get your own party. Today also with me.
Good afternoon. Nathan Claudius, Community Party Chair.
Now, today, of course, today, actually, you won't take this one.
I get two feelings. I get one side way I really sad. I get one side way I for say I glad. I sad because imagine 3 years on, we they get this kind of conversation. I wonder say if after the case law withdraw, I shock. Say 3 years on, and now with the court case like this. But on the other hand, I'm glad the way I hear some of the justices then get for say, especially waiting Justice Thompson. It give me a lot of satisfaction for no saying yes, certain things and the way they are wrong. Where you get to know what you they use the judiciary for. You cannot use the judiciary for political shenanigans, as it were. Forget your will. So I'm glad it's where this matter don't be put to bed at the whole state once and for all. Because if you were born a Sierra Leonean, why on earth you go and say I want for this side? You cannot be stateless. So I so much appreciate the fact say as a lawyer, the fact say I hear all things, and the fact say they don't make them quite clear now. Politics for politics, judiciary for judiciary. No, not they mix up the two.
In other words, forget real separation of power. Look at.
Yes.
Yeah. So in other words, judiciary don't prove the metal. But
no, I appreciate them. I really appreciate them. And I say I go particularly single out Justice Thompson.
Because a woman.
Well, she excelled on this situation. I mean, more than say I'm whitey, boy. So I really appreciate in clarity and the way we talk, let us really understand. So even the person may not get law experience like me, I able to understand exactly in point where they make. So this, the one they make, yes.
Thank you very much. I appreciate you. Thank you. Dr. Dennis Bright, of course, the chairman of the NGC. Of course, the name be mentioned a few times in that particular judgment. But, Doctor, how do you feel today the Supreme Court laid this matter to rest?
Yeah, I feel actually, because actually it didn't take so long. It don't pass 3 years. So you can imagine that as chairman of the party, when we candidates now have been challenged, I must feel relief that clarity don't do over this issue. You say would not say the papers them just recently been there with a lot of things and for sale, and they can't decide for pull Dr. KANDEH YUMKELLA in Parliament. Well, maybe they've not been there in possession of some of the facts, or something they've been in possession of the facts, but they no one to put up. The fact is that Dr. KANDEH YUMKELLA will make a decision in country for renounce in citizenship we get with the United States, and for only in citizenship of Sierra Leone we get by birth because now he born, and so we qualify for run for both as well as for Senate. So we don't do that long before the nomination self.
Is it that people don't do that, but some people then decide for ignorance?
Well, I'm not going to talk for them people because it's not legal motivation. But the reason why we feel an party, because that particular case they affect us seriously. Because people don't decide for votes for. Many of them not being votes for we again because they feel say then they waste their time. In fact, they give the impression they say Dr. YUMKELLA cannot go even there on the ballot. Okay. So it will really affect the morale of voters. And I make we feel that. But you know they say fall white. We don't come to a situation now we don't see. But one thing we're proud of now NGC. We're proud of the fact that around we now issue they benefit all citizens. Now we they try to put across. This issue also we've been done the push them even right now we're not in government safe. We they try to draw attention to the plight of people them we get dual citizenship. That dense self, especially the way we born in this country, dense self na people we get certain rights. Let us begin to think about them. So Monday under the economy of this country, a lot of them they contribute significantly to the economy in this country. Then they bail out families when we they in distress, especially with the problems them in this Sierra Leone. So all the reasons then they for make we begin look at their brothers and sisters then they where some of them not to say anything, we all understand why then did they then go get this citizenship. So all the issues then they now we don't bring up, but we're glad anyway. With this done this way we don't so. Yeah.
Thank you very much, Dr. Dennis Bright.
Thank you very much.
I appreciate you. All right, okay, Formula in the chairman for the NGC. I'll talk to the communications director of the judiciary. They are with me, Elkas Sano. Elkas. Now, of course, this long awaited Supreme Court's decision on this matter of or citizenship, you know, especially with the Dr. KANDEH YUMKELLA of the NGC and one of the other, somebody we stand as a plaintiff. Now, tell Formulem, in that simple term, that the decision we have been now this court today, what do you mean?
Formulem, we listen or they watch the program. I want me to understand today the Supreme Court judges were presided over by the acting Chief Justice, Honorable Justice Brown Mark, then deliver a landmark judgment today. The matter actually starts in a high court. The plaintiff, we mean the person we complain, the NGC, the presidential candidate, we now na Parliament, ALHAJI, Dr. KANDEH YUMKELLA, na David FORNA. It come before the High Court. In an opinion, it say the NGC presidential candidate not qualify for be presidential candidates at that time for the election for contest the 2018 presidential elections. It's the reason why, in an opinion, if we say they not qualify. Among the reasons them we give na that a dual citizen, we mean say a whole two citizen na in one na salon citizen, then the whole American citizenship. Now, when it came before the High Court, according to KANDEH YUMKELLA, then say they not feel say the High Court gets power for sit down on that matter. So they wrong can Supreme Court because to them they believe say, when it comes to presidential issues, now only the Supreme Court get that power for able to decide on that. So today, if they are today where they don't on that matter, because that man David FORNA complained, it says Honorable KANDEH YUMKELLA not qualified for be presidential candidate at that time, and the Constitution also very clear. The 1991 Constitution say if you for qualify for become a presidential candidate, you for also qualify for become member of Parliament. But I don't really want to go into the interpretation because the Supreme Court judges them today. They don't actually interpret the law for we. They make reference to the Citizenship 1973, even the amended one 2006, and even the Constitution of itself. They make reference to this judgment today not affect the candidature or not affect Dr. KANDEH YUMKELLA for loss in seats as member of Parliament. We Parliament today.
Thank you very much. At least you explain that people are not able to understand, and because it's a landmark decision by the Supreme Court judges.
Yes, but I want to also conclude on this. If Formulem will listen or when they watch the program, they notice say almost all the judges them get for read their own judgment. They waiting them believe on the particular matter. It show the independence of we judges them. It shows say this judge say yes, I agree. Say the complainant forget cost, or I agree say the procedure where they come before the court's not correct. This person here say no, me not agree with this. Me, in my opinion, that this show the independence of the judges them, especially when they make sure say the judiciary for be absolutely independence. Now that we demonstrate here today to una we listen or maybe they watch SLBC or the whatever radio station we be listen to. That now the independence of the judges them for decide say me I agree with you or I not agree with you. That's not the beauty of the law.
floor. Thank you very much, Elkas. Thank you very much. Well, Famulem, of course, today from the Director of Communications with Judiciary, and I just want to say, only one them way, of course, being the filthy to go against Dr. KANDEH YUMKELLA, we the leader of the NGC. No, it not be so, because even with all the judges them, of course, you get Justice Brown Mark as the president, Diana the head, and you get Justice Roberts, you get Justice Thompson, Justice Alusansi said, Justice Sengu Kuruma. They all sit down on this matter. Even with each of them give their own views about the matter, or give their own judgment about the matter, but at the end of the day, Dr. YUMKELLA is still the leader of NGC and is still there in Parliament. They're not able for unseat him because the plaintiff forget certain area in the Constitution where you look, we bring the matter down now the Supreme Court. Well, I hope say wanna enjoy the program from the Salon Broadcasting Corporation, because we always bring live court proceedings. We don't begin to bring Ganto now. So there are matters coming up, we'll go always broadcast live. I want to say plenty thank you. Of course, I get James Coker on camera. I get David Williams and my technical man Alexis C. Thanks to my colleagues in New Englandville, Esther Peak, management and staff. That must say they wish you a pleasant Friday, and we hand over back to New Englandville for continuing the day's broadcast. Until then, good afternoon.
A place cannot produce poems. It can only not prevent them. And